Good evening and welcome to the May 23rd, 2017 meeting of the Ashland Zoning Board of Appeals. Call the meeting to order. Our chairman, Phil Jack, has a conflict this evening. He may be here later on, but in his absence, I have been chosen to chair the meeting. My name is John Trefethen. I'm one of the members of the ZBA. First order of business on our agenda is approval of the minutes of May 9th, 2017. Josh sent those out to us for review last week. I know I commented on a couple of minor issues. I don't know whether you received any other comments or questions. Nope. If not, anyone have any questions? Otherwise, I'll entertain a motion to approve the minutes.
I wasn't here, so
I make a motion to approve the
Okay. Is there a second?
I second.
All in favor? Aye.
And I
Opposed?
abstain.
Abstained. Okay. Before we move on to the next item on the agenda, which is the 7:05 continued hearing, I think it appropriate that we all want to acknowledge and recognize a longtime member of the ZBA, Stan Danner, who resigned last month. Stan was a member of the ZBA for more than 10 years. He served for a period of time as chairman of the ZBA. We thank him for all of his service and rendered not only to the town of Ashland, but to us, and we wish him well going forward. Thank you.
Here.
I think we need to wait till 7:05, do we not?
Yes, I do.
Could we perhaps, WACA, could we go on perhaps a brief hiatus until 7:05, please? Yes. Thank you. Good evening and welcome back. Next item on the agenda is the continued hearing on the special permit for use requests for 1115 and 75 Chestnut Street and 10, 12, 13 Brook Street. This hearing was opened on May 9th. We heard a presentation by the applicant. We entertained public comment, and the hearing was continued to this evening. I understand from our planning department that a revised plan was submitted by the applicant mid-afternoon today, and perhaps it would be most appropriate for applicant's counsel to review that for us.
Thank you and good evening. For the record, Jerry Efron for the applicant. Since the last meeting, the applicant tried very hard to address the concerns of both the board and the neighbors, to try to offer measures to make the use more palatable. You've also received an additional report from the Conservation Commission by letter of May 19th, and you've also received some additional input from the neighbors. The neighbor's letter attached to it an itemized response to the first set of the proposed conditions. Although not all of those conditions were agreed to, a number of the more important conditions were agreed to without comment, and the applicant appreciated the neighbor's position with respect to those issues. We submit that the revisions made today to the plan and to the proposed conditions are both responsive and extensive. I'll have our engineer, Bert Corey, go through it with the plan, but I will give a little summary to bring to the attention and put on the record the changes that were made. One, we added no storage signs on Lot 3 in the areas closest to Cold Spring Brook. That was one of the requests of the Concom. Two, we pulled back the designated snow disposal area on Lot 3 by 50 feet along Chestnut Street, further from Cold Spring Brook, from the location as shown on the prior site plan. We also marked the easternmost boundary of the snow disposal area on the rear of the property on Lot 3 for the same 50-foot distance. The applicant moved and showed on the plan a moved porta potty on Lot 2 forward, adjacent to the dumpster, and as suggested and represented, enclosed both with a stockade fence to shield them from view. Significantly, with respect to the bus parking and the car parking on Lot 2, the location of the bus parking spaces on Lot 2 were moved further away from the neighbors and reoriented so that they now back up towards the spaces on Chestnut Street. The car parking spaces were reconfigured on Lot 2, and they were significantly reduced from the previous request for 72 spaces to 61. The snow disposal area that was closest to the rear of the lot boundary on Lot 2 was moved northeast of the car parking spaces and further from the rear abutter. The comment with respect to the contours, brought both by the direct abutter and by our engineer, was noted on the plan with the note grade to drain, so that when the lot contours are repaved, it will allow water to drain away from the Kelly property. And the snow disposal area on Lot 2 along Chestnut Street was reconfigured to allow for the reconfiguration of the parking layout. With respect to the conditions, the proposed conditions by the applicant remain the same with the following exceptions. A decrease in the number of the number of car spaces in Lot 2 from 72 to 60. Bus spaces will remain at 60 in Lot 3. Lot 2, car spaces 72 to 60. We added number 15, which, if you may recall from the hearing, with the first hearing, in response to a request from one of the neighbors, it requires the applicant to repair and restore any damaged portions of the chain link fence bordering Brook Street on either lot. And we added new condition number 16, which requires the applicant to conform to the requirements set forth in the certain letter from the Town of Ashland Conservation Committee dated May 19th, 2017. Before our engineer goes through the explanation, kind of walks you through the plan, I'd just like to make a couple of brief comments with respect to the way I see it from a biased perspective, obviously as an advocate, of what the contentious issues are. And it's not to limit any issues that might be in contention. But I think the major issue of contention at this particular point is the total number of buses to be parked and the parking of any buses at all in Lot 2. When you take a look at that, I need you to go back and remember the testimony and look at the sheet 1, the existing conditions plan, which has not been revised. It shows 45 bus spaces and 42 car spaces on Lot 3, 41 car spaces, 93 total spaces. It shows 109 total spaces on Lot 2. You'll remember the pictures that are in your folder. In 1966, it looks like all of those 109 spaces on Lot 2 were used. And there's been a significant amount of spaces and parked cars there for years. Currently, there are no legal restrictions on the use of Brook Street or Columbus Ave by any owners of any property, including the subject properties. They are long-established public ways, and they are not under any restrictions whatsoever. However, the applicant is proposing, as a condition of the special permit, the voluntary restriction on such use. Today, because of some site work, the the buses had a route down Columbus Avenue because something was closed. There's a qualitative difference between having the buses going on Columbus Ave and not. Without a special permit at all, it will be impossible to impose that condition. When you look at this, it's easier, frankly, for the company to operate without regard to the limits that it has proposed. It is easier for them not to restrict themselves to the number of buses. Is it easier not for them not to have to propose and produce and spend money on certain site improvements? It is easier for them not to have to be under the threat of a condition violation for protocols for their drivers, which, as you know, have been proposed to be a condition on a legal permit. No building inspector, including the current building inspector or the two previous, has ever questioned the zoning rights of the use of these lots by anyone, by Connolly Bus, by its predecessors, or by any of the users of Lot 2. It is uncontested that the bylaw in question did not come into existence in 2009. It is uncontested that the use predates that, certainly for bus parking on Lot 3 and for parking, at least of certain varieties, on Lot 2. There is a valid non-conforming use here. We're not here to debate the standards of that use. We're not here on a contest of exceeding that use, but I'm here to tell you that a simple increase in the amount of vehicles has not been held without more to be an enlargement of a prior non-conforming use. And I ask you and those that may speak in connection with this case, reflect upon that and reflect upon it carefully. Bert, could you go through the plan, please?
I just wanted to let the public know you will have an opportunity to comment upon the revised plan this evening after we hear it. We sort of ended public comment at the last meeting, but obviously with a new revised plan being proposed, we will open it up to public comment once again.
I agree.
Good evening. My name is Bert Clory. I'm with Schofield Brothers. I brought some plans with me, so if I may, just to pass these out around the table, and then I can talk from the board.
That would be fine.
Sir, could you keep your voice up, please?
I think we can probably share, yeah. Might be the easiest.
That'd be good.
Due to the size.
That's okay.
Long reach. Actually, I could talk right from here, if you don't mind. Okay, so just to start out with the on the snow disposal areas, as you notice on the plan, working from Chestnut Street on the south side,
Jerry.
starting from the brook area and moving 50 feet away, we are proposing some signs to be placed along that parking area. Are you following? Yep. So that portion right there would be a no disposal area. So it's a clear 50 feet away from the brook. The remainder going along Chestnut Street would be a snow disposal area up against the existing fence on the backside of where the buses would park. Continuing a little bit beyond Brook Street, we have a much larger area of snow disposal. That occurred from the modification to the bus parking, which I'll get into in a moment. But we have a fairly large area, relatively, compared to the site, for snow disposal. It's a little bit further away from the brook, which I think is beneficial. Along the backside, or on the west side, towards the abutters, there's a small snow disposal area at the end of some of the parking spaces. There are no snow disposal areas along the abutters of Lambert and Kelly. There's actually a 6-foot buffer right there. We do have a small disposal area continuing on towards Brook Street. Again, a small area, but it's a place to put some of the snow. Continuing back onto Lot 3, along the west side, we have another snow disposal area. That buffer area ranges from 7.7 feet to 7.8 feet in width. And it continues on to the south until it reaches a sign again that says no disposal area. Again, that's about 50 feet away from it's actually from the edge of the pavement that abuts the brook. And then along that edge of pavement that's along the brook, we're also proposing to post signs there for no disposal. And I think that was some discussions that Jerry had with the Conservation Commission. As far as some of the revisions to the plan, we did take the 9 buses that were on the north side of Lot 2, and we reoriented them 90 degrees so that they're backing up against the Chestnut Street. So that is certainly a difference between the last plan that was submitted, and it was in response to a point that was brought up by the abutter. In doing that, we needed to reconfigure some of the parking in that area, and we lost several car spaces in order to facilitate the buses from maneuvering within that area. And I think Jerry just relayed the difference. I think we went from 72 to 61 car spaces in that area. On this plan is also highlighted the locations of the 6-foot high wood stockade fences, which essentially shield the parking areas from the abutters on the west side. On Lot 2, you can see along Traynor, Lambert, and Kelly, there is a 6-foot wood fence that would run close to the property line. On Lot 3, there's also a 6-foot stockade fence that would run from Brook Street heading south along, Linder Fowler Paradise, along that abutter. And it would stop at the corner of her property. As far as the porta potty and the dumpster, they've been relocated to the east, over by the largest snow disposal area at the corner of Chestnut and Brook Street, and they've been surrounded with, again, another 6-foot tall stockade wood fence, just to shield some of that. Those were the changes. Also, too, where the proposed curb cut is on Lot 2, we added 1 more bus space in that location. So that brought us up to 60 bus spaces on Lot 3, rather than the 59 that was originally proposed. That's it in a nutshell.
I'd like to ask a question. On parking lot 2 in the snow disposal area, when you don't have inclement weather, do you anticipate any type of parking there?
No, it's not set up for that. It's not going to be striped for that. It's not to be used for that. As a matter of fact, if there was a full set of parking that was in that area, it couldn't be accessed with a car. That's not to say that the 4 car spaces that are in front of that, this is kind of an odd situation in that the parking is not like a mall or some type of a retail facility. There's a lot of comings and goings with traffic.
No, my question was going to infer that, people park where they want to park. They just see an empty spot and they park. So
That's an area that could be striped with diagonal striping, just to display that there's not supposed to be any parking there.
So the snow disposal areas are gonna be bituminous concrete?
That's correct.
On lot 2, the original design had showed a potential curb cut onto Chestnut Street from lot 2. That curb cut, because of the rearranging of the bus spaces, is no longer possible on lot 2, is that right?
That's been removed from the plan, yes.
Okay.
Sorry, I should have mentioned that.
The opening from lot 2 onto Brook Street, there's just one opening onto Brook Street from lot 2, or two? I just want to make sure I'm interpreting the plan correctly here.
There are two openings.
Two openings, okay.
Yeah, there's two existing openings right now. They're shown where the double arrows are.
Okay, and keep those, okay. I got it, thanks. This would both go sliding under the table.
I have copies. If I mean, obviously, you can't see what's happening here. So if anybody wants a copy, I use that here.
On the original plans, there was going to be the elimination from one of either lot 2 or lot 3, I don't recall which, and I was looking for it on the plan, but I can't make out because I didn't bring my magnifying glass, from either lot 2 or lot 3 onto Brook Street. Were any of the openings from the existing parking lot as it presently exists being closed off, or are they both all going to be front and center on the new proposed plan?
Yes, the uppermost opening on Brook Street, closest to the abutters, are being eliminated.
It still is, okay. Any other questions from members of the board on the
Well, I wasn't here
plans?
2 weeks ago, but I do have a question. In the memo to the Exhibit A to the drivers with various instructions, it does say no right turn and no left turn when you're departing the appropriate lot. But is there going to be any signage there saying no left turn or no right turn?
Yes.
Yes.
Okay.
That's a written.
Wasn't here, so.
Any other questions from members of the board?
No, I'm good.
Okay.
Thank you.
Okay. At this point, why don't we open it up for further comment from members of the public? And I would ask, if possible, to limit your comments to the revised plan. We all remember very well the comments that were made at the last hearing, and were We remember them. Yes,
Good-
counsel.
Good evening, Mr. Trefethan. How are you? My name is Amanda Zaretti, and I'm representing Elaine Kelly and several of the abutters who reside on Columbus Avenue and Brook Street. I would like to make two comments that do not specifically address the plan in order to address the legal points that Mr. Efron made in his remarks. Both on May 9th and this evening, Attorney Efron has stated that his client has voluntarily submitted itself to this application process and intimated that his client's use of the pre-existing use of the area is a pre-existing non-conforming use for which no special permit is required. I would suggest that any appeal on that issue is now time-barred under General Laws Chapter 40A, Section 15, and Mr. Costa can advise you as to whether that interpretation is correct or not. Mr. Efron also implied on May 9th at hour 3, minute 16, that while the applicant was not asserting that its proposed use of the premises is a pre-existing non-conforming use, quote, tonight, meaning on May 9th, that he intimated by tone that the applicant might do so in the future. So to that end, and for the purposes of the record, I direct the board's attention to Zoning Bylaw Section 3.2, which addresses non-conforming uses and structures. It is true that to some extent, this area has been used for parking for a very long time. In fact, Mr. Traynor, who's resided in the neighborhood since 1957, testified to that fact. But he also said, let me address the standard first, and then I'll talk about his one-line testimony that I think you should recall. The zoning bylaw shall not apply to uses lawfully in existence or lawfully begun before the first publication of the public hearing required by Chapter 40A, Section 5. We all acknowledge that the zoning bylaw for this area was not in effect until 2009. But Section 3.2.3 of the zoning bylaw also says that the Board of Appeals may award a special permit to change a nonconforming use in accordance with this section only if it determines that the change or extension shall not be substantially more detrimental than the existing nonconforming use to the neighborhood. What I was getting at is that Mr. Traynor testified that the original use of the parking was for accessory use to the building at 200 Homer Ave, and that it was for employee parking of automobiles only. It was never a commercial parking lot. Then he also testified that the use of Lot 3 for Ashland school buses began about 20 years ago, but at that time there were only 10 to 15 Ashland buses and that they were parked close to the Sudbury River. And I quote, "As the years go by, the number of buses just keep creeping up." Even if Mr. Efron is correct that the client's use of Lot 3 is a prior lawfully existing nonconforming use, there really can't be any reasonable disagreement that the applicant's anticipated and proposed use of Lot 2 is clearly a modification that extends that nonconforming use, which brings the use of the premises squarely within the purview of the Zoning Board of Appeals under Bylaw Section 3.2.1. So, that said, the abutters' testimony of their experiences on May 9th establishes a factual record of what they have experienced, and the applicant's conditions, as proposed, are responsive to most but not all of the applicant's concerns. Really, the two things that remain for the applicants, and they will speak beginning with Ms. Kelly very briefly, are the issues of the curb cut and the issues of plantings. As you know,
could you repeat the second one, please?
As to the issue of the curb cuts
Yes.
and the plantings. Okay. With regard to the curb cut, you are well aware that this property is in the floodplain overlay district of Ashland because it is within the Zone AE on the Middlesex County flood insurance rate map issued by FEMA. So at hour 4, minute 5 of the May 9th hearing, Mr. Efron said that the applicant is wholeheartedly in favor of proceeding with the construction of the proposed curb cut on Chestnut Street. And the revised plan shows the location of the new curb cut. What the revised plan also contains is a notation that the curb cut will require saw cutting of the pavement. Right now, the Conservation Commission's May 18th letter says that the only requirement is for snow disposal, which is fine. But come the day when there is a proposal to cut into the pavement, that is going to trigger bylaw section 8.1.4, which requires that no earth or other materials be excavated unless a special permit is granted by the planning board. I would suggest that under bylaw section 9.3.4, Mr. Costa, I know, will advise you as to whether that's correct, That section affords this board the authority to grant this special permit with a requirement that the applicant apply for that curb cut by a date certain. Obviously, you can't control the determination of any other board, so it's not reasonable to say that the applicant must obtain the permit. But at the very least, this board can require as a condition of the special permit that the applicant apply for the permit in a timely fashion, perhaps within 30 days of taking title to the premises, which I understand is anticipated at the end of this month, but Mr. Efron can say whether that extension date is correct or not. I'm going to leave it at that. Thank you very much for your attention, and Ms. Kelly will speak first.
Thank you.
Hello, I'm Elaine Kelly of 18 Columbus Ave. Back to the plantings, I have a diagram for you guys to look at. This is our street with each house labeled, and this is the view from every street into that parking lot. So when we're talking to you about trees, this is why, because this is what we're looking at. I tried to get pictures of most of them, but they all wouldn't fit. Every house on Brook Street and Columbus Ave look into both of these parking lots. We have asked the board, we have asked MJ Conley if we could have the trees for what the bylaws tell us that they have. They were kind enough to offer us a stipend to plant some trees, which they sent and we submitted back to you. In the process of talking with my neighbors and getting a couple of estimates from a landscaping company to come and plant the trees, we have the first estimate for my neighbor Linda, who's at 14 Brook Street. It's going to cost $8,500 to do the trees, to remove what's there, to plant the new trees. The stipend for them was $2,600, so we're not even close to what we would need in order to plant trees on our own property, then maintain them and take care of them. So we're back to, in the bylaws, it says that they need to have trees and fences put in, and we would still appreciate to have those. Or we I guess, demand to have the trees, as the bylaws say. They say that they can't water them. They bring water in to wash the buses. They can bring water in to water the trees. But every parking lot, every house sees this parking lot. So we are still requesting that we get the trees as the bylaw says that we get. As for the curb cuts, they, part of our first conversations with them, as they have said, we asked for the curb cuts to be in there. If they're not gonna pursue the curb cuts, then we don't want any buses in lot 2, first of all, and then it should be limited to what is in lot 3 at the moment, because what's coming out of there already, it's too congested for one small area. There haven't been any traffic studies on Chestnut Street and that intersection having that volume of buses coming out with just the 47. Now they're saying 69. That's a lot of buses coming out of one little tiny street that's already tiny to begin with no sidewalks. And if the curb cuts aren't there to kind of spread it out a little bit, then it's going to sink that street, literally, which it already is. But and then we have the snow. They move some of the snow, and from what I can tell, now it looks like they're pushing it all up against 14 Brook Street. Is that correct? Is that one of the snow areas?
There's a small area right here. Small striped area.
On this side. Is this all snow storage right here? All right along. This is Brook Street. Yeah, she's Brook Street. Well, the Brook Street resident, 14 Brook Street, is all piled up along the edge of her property. Which she also has some water issues, I guess. Water, when snow melts and water, we have a good amount of rain. It does head into her yard as well.
To be clear, 14 Brook Street is the Trainer property?
No, it is the Fowler property.
I'm sorry, which one? Kelly?
Mercer.
Mercer?
Fowler. I don't know what's written on the thing.
This one,
Which one?
It's to the right of Brook
To
Street.
the right?
the
Okay,
right of Brook Street.
I gotcha. And the letter from the landscaper refers to trees, but it doesn't talk about what kind of tree. Do we know?
She has the pictures of what it looks like. She has trees there's all kinds of little sapling growths, and there are a lot of trees on her side that would have to be removed, and the ground would have to be prepared in order for any kind of shrub or tree or anything to be planted on her property, as the stipend that the bus company had offered us, that the trees would be planted on our own properties. And her property is the worst, and that's what we got the estimate for. So they offered a stipend. They broke it down for the amount of feet and a certain amount per tree for the stipend. But just her yard is the worst of all, because she has all the buses are backed up to her house right now. And she has all the growth on her side. So in order to try and plant these trees to screen it, it would be very, very expensive. Yep.
Any questions for Ms. Kelly? Thank you very much.
Thank you.
Ray Trainer, 8 Columbus Ave, Ashland. A couple of things that I think we need to look at. Those pictures that you saw, all the cars parked in the parking lots, was when Bernardi Honda, I think it was Bernardi Honda, used to store cars there. That was just dead storage. They were just parked there, and that was the end of that. I do take exception to the fact that the prints weren't made available to anybody to look at till this afternoon, so we really didn't have time to digest it. As far as planting the trees around the perimeter, I think they should certainly put it in their own side. The statement was made, there's no water on the property. Well, there's no diesel fuel on the property, but they bring in 4,000 gallons a week for that, too. So they can bring water in to water the trees put on their own property. The drainage issue of the parking lot going back into the river has still not been addressed. Now, I have pictures showing it going in, and I know they might get upset, but we also have pictures of all the oil strips that are currently in the parking lot. All of this washes into the river, and nothing's been addressed, and it's going to get worse. And as far as the porta potty goes, I think if you check the OSHA website, you're supposed to have one porta potty per 15 people, not one per 60. So that just brings another whole porta potty issue into it. So that's my statement, that the trees should be definitely put in, as it calls for, definitely be put in on their own property, and they can maintain them. If they can fuel buses, they can water trees. And as far as the curb cuts go, we haven't had time to digest it because the documents weren't available till 2:30 this afternoon. So other than that, that's pretty much all I got. That I think it really needs to be looked at a little closer. If you want these for the...
I have a question for you.
Go ahead.
The trees and where they're put.
Yep.
On the
Should
parking
be-
lot property or the
Well, I think the
butters
bylaw,
property?
calls to have the trees put on their property. Let
Okay.
maintenance become their problem, not ours.
Okay.
I know it's going to be a problem because when they plow the snow in there, they're going to kill the trees.
Right.
And it's just going to have to deal with it every year. I mean, it's just something they're going to have to deal with. I don't know what the answer to it is, but the bylaws certainly state we're entitled to the trees, not on our property, but theirs, because then the maintenance becomes our problem. And then it just takes up our property when it could take up theirs. So, any other questions? I think if you see that, you'll see the guardrail is right along that, I believe it's called Colebrook. That guardrail is where the water just goes right into the river.
Yeah, last year when they were doing the pipes, water pipes,
Oh,
sewer
God,
pipes,
yeah, that was
there was
total-
a lake in there.
Yeah, and that all drained into the river, and they
Yeah.
tried like hell, but it still went in.
It wasn't us.
No, it had nothing to do with them. Had nothing to do with them.
It happened.
It was Mother Nature.
But the reality of it is you can see where it went. That was a perfect example of where the water goes. It had nothing to do with these people. It was not had nothing to do with them.
It was other users of the property.
Oh,
It wasn't
The
us.
question, the other question I've got, because I've been there for so long, if they're applying for a special permit now, what permits are in existence to park there for the last 20 years? Has there ever been a permit? Or did everybody just park buses and that was the end of that?
There was no requirement of permits.
It wasn't?
That's correct.
All right, well, that's up to them to decide. Yeah, so that's all I got to say.
Thank you.
Hello everyone, Pankaj Angan, I live at 14 Columbus Avenue. I'm the direct abutter of lot 2 parking lot. So I have 2 kids, one is 3-year-old and other is 9-month-old. So I want to ask, how can you imagine my kids will grow, park like 60-70 buses in my backyard, fuming diesels every day, starting early morning 5:30, and while coming back they keep making all the noise. And so both of my kids wake up every day 5:30 because of the buses starts making noises, and that's the issue ongoing. And I'm not sure how we can deal with when there are more buses parked on the same parking lot. Now regarding the trees, I don't know why the bus company has problem following the bylaws. Bylaws says that you need to have trees on your property with the buffer zone. So I'm not able to digest why the company is opposing to have trees on their side. Let me give you an example. Let's say I want to set up a business, I want to set up an office in a commercial zone. The place doesn't have any utility, doesn't have water. Now I am setting up an office which has like 10 employees. Now employees need a restroom. Will you allow me to set up an office? And I say that my property doesn't have a utility connection, so I'm not going to set up a restroom. Will you give me a permit to set up an office there? That's a question to the board. I'm hoping that everybody likes to follow the rules. So if I'm in that position, I would like to get a utility connection, whatever is required to serve my employees, and not just go with the loopholes in the current laws. Now, right after the last meeting that we had here on May 15th, I took some pictures. So there are buses blocking the Brook Street. They didn't stop in the parking lot while exiting. There are bus parked on the lot 2, which they do not have permit right now. There was buses parked there, and that's like completely against the law. I would like to submit these pictures there. These pictures are taken on May 15th. And every day buses pull out from that parking lot 3 without stopping before entering to the Brook Street. And I would like to bring one point here. So there is a Sunset Street on Ashland which has a sign that not a through way. Can we have the same sign on our street, because it's not a through way? Sunset Street is a public street, but still it has a sign that not a through way. I think we should also get a sign on our street. I'm not sure if there's anything we need to do for that. All the neighbors are ready to do that. If we just need to know that what steps we need to do that. And during the summer, the bus company says that there is not much activities, but during summer also there are trainings. When buses will go out, they need to move buses for washing them, and for servicing those buses. So during summer also there are a good amount of activities going on in the parking lot. So it's not a completely quiet zone when it's a summer or vacation time in the school. And the last question I would like to ask the board is, what benefit does the town has by increasing the number of buses in that parking lot? I don't see any benefit to the town by increasing the buses in that parking lot. If you talk about that the town will get excise taxes, I don't think the company is paying excise tax to the town since last 20 years. Is the company paying the excise tax to the town since last 20 years?
Yes.
Does it?
Yes.
Or it just paid this year and
No, every year, sir.
to the Ashland town?
You can check the record.
Please address your questions to the chair and your response to the chair, please. Thank you.
Okay, so that's it I would like to bring, but my serious concern is about the health of my kids. If my kids wake up every day 5:30 in the morning in the middle of their sleep, it's going to seriously affect their health. That's it. Thank you, board.
Thank you.
Good evening.
Good evening.
My name is Enrique Araya. I live in 7 Columbus Avenue. I've been there for 28 years. When we purchased the house, there was a nice, quiet neighborhood. That was my piece of heaven. Right now, it's turning into my piece of, I'm not going to say it on TV, but you know what I mean, the opposite of heaven. When we moved into Ashland, there was no buses parked there. And a little bit at a time, they started parking in there, and more and more and more. Going back to the exile taxes, we know that they paid this year $69,000. What happened to the 19 past years that they didn't pay for it? That's about, hang on a minute, I'll do it on my calculator. $1,300,000 and change that they didn't pay before. What happened to the money? You know how much equipment the high school can buy? The football team can get new equipment. The soccer team can get new balls and uniforms. I think it's worth to have one of the lawyers for the town to investigate. Maybe recuperate some of the money and even some of the interest. That's a lot of money that we can use. And anybody can correct me if I'm wrong, if they pay for the 19 past years.
If you don't pay your excise tax, you can't register the bus the next year. We pay
Yep.
excise tax every year, every vehicle that's parked in Ashland.
Yeah, but who do we pay to?
The town of Ashland. The registry sends the bill, just like for your car, in a personal car. We pay the bill back to the town of Ashland. Buses that are parked at Walpole, we get the bill for the registry, just like you get it for your car. And then the bill, you send the check back to the town that the bus is parked in, the town of Walpole in that case, or the town of Ashland in this case.
Well, can somebody please make sure that that's true? Because I heard in one of the meetings, oh, well, we send a check for $69,000. Kind of making it look like, yeah, well, okay, they send it for 1 year.
sir,
What about the rest of the years?
The payment of auto excise taxes is something that this board has no control over or power over. If there is a question about it, then I suggest you take it up with the Office of the Town Tax Collector or the Registry of Motor Vehicles. But it's not something this board can deal with. We have no authority to deal with that.
All right, I'll do more digging.
Okay.
One more thing. I want to find out what time does the first bus leaves the yard in the morning? I mean, there's a lot of you guys here. You can tell me what time.
I leave at 6 o'clock in the morning.
6 o'clock, okay. We have a bus leaving at 5:30 in the morning, and it happens that one of my coworkers goes by TJ's at 5:30 in the morning. Was that bus that leaves at 5:30 in the morning and wakes all the neighbors, goes to TJ's for coffee, for breakfast. There's a picture that he took here and he gave it to me. Why they're allowing that stuff to go on is beyond me. If they don't have control of their drivers, what's going to happen? To me, that's the drivers, and I'm not saying all the drivers, some of them, because I know some of the drivers from Ashland and some of them from Hopkinton. I've been in parties with them. They're very nice people, and they do everything by the book. But some of them, it's the completely opposite. They have no respect for the neighbors. They have no respect for the company. And those are the people driving our kids. Please, take control of your drivers, please. You have to do some management, some training, and a lot more than that. Thank you.
Thank you.
Hi.
Good evening.
My name is Linda Mercer. I'm listed as Linda Fowler Paradis. I live on 14 Brook Street, and that's right on Lot 3. I have some pictures here. I'll just give you this for now. This is my property here, and that's where the buses are. So they're real close. So now I'm going to have about 60 buses in my backyard. And as I've mentioned before, I'm really okay with that, but I would like to have...
When was this picture taken?
Oh, no, I'm sorry.
Just when, that's all.
May. May 2017. Most of them do have it on the back. Tonight I want to address the street itself, because when I was here last time on May 9th at the meeting, the question, I asked the same question, but I didn't feel like I got an answer. So I'd just like to know, on the street, Brook Street, that I live on, there is a lot of debris, a lot of leaves, old dead leaves, not just from winter, but sticks, coffee cups, lottery tickets, dead trees, old leaves. And they've been there a long time. And, you know, we live on that street, and people come over for barbecues. And, you know, I don't want to have to send them around the other way. It'd be nice to have a street. I mean, the buses are there, but we can still have a nice street with some trees that live, and or no trees at all, something, at least some.
Is the debris inside the chain link fence on that property, like Lot 3 and Lot 2, or is it outside in the street? You don't need to show me a photo.
Okay.
I just am
It's
curious.
both. And I don't know.
Okay.
Is it the town? Is it 200 Homer? Is it Connolly? I don't know who's in charge of that. But, you know, I'd like to find out, because it's...
Certainly, I mean, I would suggest that if this board decides to grant a special permit, and I emphasize the word if, we can place a number of conditions on the grant of that special permit, and one of the conditions could be to clean their property up and maintain it in a neat and clean condition. I don't think we have the authority to require them to clean the street itself, which is a public way and not their property. That might be the issue.
Yeah, well, it's more the litter and the leaves and,
Sure.
and dead foliage that I'm concerned about, not so much the street. I mean, I would like to submit these pictures.
Sure.
Permission to bring them last time. And, I had a question about the fencing, the stockade fencing that was discussed before in the new plan. I'm wondering if they're going to leave the chain link fence or replace it with the stockade fencing. I don't know if they know that yet, but I'd like to know what their plan is for that, what the Connolly's plan is for that.
Well, perhaps I could ask Attorney Efron, what your client's...
The plan is to use the wood stockade fence where labeled and shown on the plan around the perimeter of the property to maintain the chain link fence on Brook Street and to repair any areas of the Brook Street fence where damaged.
Correct, but on the chain link fence that presently abuts the neighbor's property, that would be removed and replaced with a wood fence?
That is correct.
Okay.
Okay.
Is that what you want? You want us to take the fence down?
Well, I was kind of thinking it would stay a support,
Okay,
you know? I mean, that's what I was thinking.
okay.
Because if the,
I
might,
thought you wanted it down, so we
not
can... we'll
really,
talk.
okay.
We could talk.
Sure.
Through you, Mr. Chairman, sorry.
No, that's quite all right, sir. No offense taken.
And you already talked about the chain link fence that was damaged. I remember hearing that earlier. So that's all I need, that's all
Thank
I
you.
have tonight. Thank you.
Good evening. Steve Morgan, 136 Concord Street. I had a question, I guess, first. Is there a wetlands delineation for this project? I didn't see one. I've heard discussion about a wetland area, a brook, and so forth on the property or near the property, but I haven't seen a wetlands delineation. So does somebody have that in the record?
There is no wetland delineation.
Okay, so I saw this, I monitor a lot of agendas in town to look at open meeting compliance. I saw this come on the agenda for the Conservation Committee, and I saw it come off the agenda. And I understand there's now a letter been generated by the agent, but the Conservation Committee has not met on this project. It's my understanding. And, you know, again, you're talking about proceeding with a project on a set of assumptions with a wetland resource, which sounds like there's flooding, sounds like there's issues with salt and snow, but yet there doesn't appear to be an operational plan here in the record as to how that's all going to actually happen. And then perhaps, you know, I would suggest that there should be before anything gets approved. Certainly, the conservation agent's employee of the town, but the conservation agent does not have the authority of the Conservation Commission to review determinations on wetlands. This clearly is affecting the water resource. It's nearby. I believe there's a no-touch zone as well as a permitting zone. They may not be digging now, but it sounds like they're going to be digging in the future. So I would just suggest that before you take any action, that somehow get into the record. Not trying to suggest it'll be unsuccessful, but it should be in the record, in my opinion. In regard to the criteria, I guess I'm concerned that this project was out in front of the Board of Health. I attended a meeting, noise bylaw. We just passed a new noise bylaw at the town meeting. Apparently, we can't blow leaves before 8 o'clock, but we can cut our grass by 7. But yet we can run all these buses at 5 or 6 in the morning. It's not clear that this would even pass muster by the new noise bylaw, but I think it's very inconsistent with what the town meeting just voted to allow this to continue to be the case. I don't see anything here about diesel mitigation. There's been a lot of work done in certain jurisdictions. I was in California for a while. Years ago, they had diesel mitigation systems to pick up fumes. Don't see anything in this plan to deal with the fumes. I understand it's supposed to be in front of the Board of Health. Apparently, they haven't been able to meet on that, so I would again suggest that it's premature to grant any relief until the record is complete in regard to how that would be handled. I'm very concerned with what I heard about where the trees go. I think it's unquestionably the requirement of the applicant to find property that they control and own to satisfy all the buffer requirements, all the setback requirements, whatever might be necessary on their property. I look at that plan and I see a lot of density on that plan, and I would suggest this is like many other zoning issues. There's too much density there. It needs to be reduced to an operational level where it can actually work effectively and not overload the streets. Again, neighborhood character and social structure is a very important part of the decision process, as is adequacy of services, which would include streets, I would believe, traffic flows and safety. There's no reason for this kind of density in that one place. Certainly, it's beneficial to the bus company. The bus company helps Ashland, but it's not necessarily, these buses are not for Ashland as I understand it. They're for the overall use of the company, which I'm not against the company, but I would suggest that this density is too much for this size lot, even with the additional lot. And it's really been running out of control for a long time. I'm not the legal scholar to tell you whether it does or does not require a non-conforming permit. I think town council can do that, but it seems pretty clear from my reading that there's at least a case to be made that this has been a non-conforming use that should have been conforming when it was expanded. There have been a number of cases about buildings expanding, and I would think that this would fall in the same category of decisions where when you go from, say, 20 buses to 40 buses, that's an expanded use requiring a site plan, requiring a lot of documentation. And so I would suggest that this record looks pretty thin with a one-sheet drawing in all the meetings that have been taking place, and I would think you'd want operational plans. Many of the things that were in a site plan review, I don't think you necessarily have determined this requires a site plan review, but it is clearly a significant change in the nature of what's here, and that information would support a yes or no on this topic. So again, just to finish off, I would hope you'd wait for the other boards to get involved in this topic where they belong and fill out the record with actual technical information as opposed to just pushing along. So thank you.
Thank you. Mr. DeSoni.
Good evening. And I'm going to do almost the same sort of theme here. Mark DeSoni, Hawthorne Road, 49, lifelong resident. Through the chairman, can I ask Josh a question?
Sure.
Okay, now Josh, you're part of the planning board, right? Yeah, a little bit.
The planning board?
As
I am not.
Office.
Planning department.
I am a part of the planning department. I am not part of the planning board.
Okay, now before I ask my next question, what's the difference?
He is an employee of the town of Ashland. He's the assistant town planner, if I understand your position correctly.
Yes.
So when asked by the planning board for ideas and thoughts and stuff, you do have an input.
When asked, yes.
Okay. Now, in that theme, this plan right here, is this a first or second plan that's in front of you, zoning board?
This is the first application for a special permit for use filed by this applicant.
Okay.
And what we have was a plan that was presented when that was filed, and we now have a revised drawing with a revised plan that was presented to us today.
Okay, now, combination, Chairman, and to Josh. This is the first time of a site plan in this board? Chairman, I'm asking that to you.
No, there was a plan filed with the application that set forth the proposed project for use.
Okay, now, excuse me. Now, Josh, as part of the plan, assistant planner, do you see plans coming into the office from the applicants, and they show you firsthand before what they're gonna be doing, and then you talk over with them on what it is?
On occasion, yes.
This plan that they bring in for zoning board, is this the first time that you've seen this?
No, Mark,
No, well, a reason, there is a reason.
well, make your point if you would, please.
I
'cause
will,
I'm not gonna-
I'm making the point in procedure. So Josh, is this the first plan or second plan before the planning board ever got to see it in their agenda?
No, the plan that the zoning board of appeals is dealing with is the plan that we have. Whether there was or was not something previously filed that was not brought before us is not relevant to our discussion, and we're not going to go down that path.
Procedurally, I will go down that path. The town has got to know that usually it's the planning board that sees it, then they talk about it, then they get the conditions, and then it comes to the zoning board for residual conditions, and back to the planning board as a plan updated.
That is not the procedure with a special permit for use that we are dealing with tonight. The zoning bylaw gives the zoning board of appeals the jurisdiction to hear that application, not the planning board.
And what zone in bylaw is that?
Special permit.
The special permit under the for use, I don't have the site directly in front of me.
9.3.
And can you read that zoning bylaw, please, for this?
Sure. 9.3.1, special permit granting authority on less specifically designated otherwise, the Board of Appeals shall act as the special permit granting authority.
Okay.
And Mark, just under section 3.0, principal uses, paragraph H, other uses, a commercial parking facility, the Board of Appeals is the entity that hears use special permit requests in the type of zoning neighborhoods that are involved in this application.
Okay, now
So
through the
they are
chairman.
where they are supposed to be.
Okay. Now, through the chairman to the town attorney, Mr. Costa, is this a commercial zoning bylaw that's going on tonight?
Through you, Mr. Chairman.
Yes, go ahead.
I'm not sure, sir, what you mean by a commercial zoning bylaw. The town of Ashland has a zoning bylaw that divides the community into districts. In this particular district, as the chair just read, this sort of a facility is allowed by special permit issued by the Zoning Board of Appeals. There are instances with other uses in other districts where there is both a special permit requirement for that use to exist, as well as a site plan review requirement under section 9.4 of your zoning bylaw. In those instances, and those might be what you're referring to, an applicant would make application to the planning board for review of a site plan and would often come to the zoning board of appeals either simultaneously with appearing before the planning board or subsequent to appearing before the planning board. This is not that sort of a project. There's no indication from my review that there is a site plan approval required from the planning board. Consequently, the only application that's been made by this applicant for this project is to the zoning board of appeals. There's nothing presently pending before the planning board. The applicant can speak for himself, but I don't believe it's the applicant's intention to make any sort of an application to the planning board.
Okay, thank you. Back to the chairman. To the engineer, what's the difference in diameters in the original parking lot to the one that's going to be used new?
Difference in diameters.
On the microphone, please.
I'm not quite sure your question on the diameter.
How wide is one compared to the other? You can have more buses.
Are you talking about the parking spaces?
One, you got the original spot now, where the buses are now. Across the way, it's empty squares, an empty big parking lot square. How much is that, is diameter compared to what it is used now?
Diameter or lot?
Square space.
Square feet footage.
Square footage, okay.
Okay, so lot 3 right now is 84,500 square feet. Lot 2 is 38,774.
So you got twice as much in the second one. In the first one, you just said.
Lot 3 is approximately 2 acres if you want to round. And lot 2 is about 3/4 of an acre.
And there's going to be 20 plus more buses in lot 2, the 83 square. The more buses in the newer one,
There's proposed 60 buses. in
Yes.
Lot 3.
And what's in the original?
In
The first
original-
one.
In the original, there's 45. On
And-
lot 3.
And were those buses, along with the driver's parked cars, going to be there in that same lot too?
No, there'll be no car parking proposed for lot 3.
Lot 3 is all.
Presently, there's bus spaces and car spaces in lot 3, totaling over 90 combined spaces.
Well, thank you. And for the width of Columbus and Brook Street, which are not exactly wide, if in our wish list on my side, and hopefully it will help the residents there, shouldn't there be a width and time of residences that can use the roads and have Brook Street only off of Chestnut Street for the buses back and forth, so they won't have to crowd the residents living on Columbus Road? Because you got to consider they're living there, the buses are coming there, and if nothing gives, it's going to become adversarial, and it's going to become more of a hurting coexistence than trying to compromise. And so far, there's been no compromise with the buses coming down there to what there is in all hours. All that's town, and all that's what you gotta go through, and that's why I was asking about the site plan and the diameters. Thank you.
The document that was provided by the applicant for new rules specifically say, and I will quote, "Columbus Avenue shall be avoided completely, personal vehicles and buses."
Okay?
And if you're exiting from either lot onto Brook Street, you can't turn down and go towards Columbus Avenue on Brook Street. You can only go to Chestnut Street to translate what the applicant has said. So I think that pretty much answers your
Okay, so
question.
that answers that question. Thank you.
Yes.
Now, the last thing, I would say, they want that lot, and this is about the trees and brush and stuff like that. I'm agreeing with the residents is saying they should not have to worry about the plants. If it's there, the buses company, it should be theirs on their side, not on the abutter side. Thank you.
Yes, sir. This will be the last public comment.
Paul
Unless
Connor.
there's someone else that hasn't already gotten up, but please do so now, because we're going to cut this off.
19 Columbus Ave.
Thank you, sir.
Just curious, the town says that the buses that service the town of Ashland have to be parked in the town of Ashland. That's, I don't know, about 15 buses. Why doesn't the town provide a spot for them to park? Just a question.
That would probably be better addressed to the town or the school department.
Okay. A lot of the buses that are there for Hawkington, why do we get stuck with them? They're only a contract carrier there. In 3 years, when their contract is up, the town could throw them out and get a new bus company. Where are they going to park? And are we still going to be stuck with 70 buses at our house that don't even service the town of Ashland?
I understand.
Okay. And then just one last little comment that really is what made me come up here and speak tonight. As I was sitting in the back of the room, I think that's a Conley employee or a Conley higher up or one of the owners or whatever. And while one of my neighbors was speaking, he, under his breath to his buddy, was saying, if you don't like it, why don't you just move? That's our good neighbor. I think that says it all. Thanks.
Yes, ma'am.
Good evening. My name is Judy Margulies. I am a member of the Ashland Board of Health. I'm here only to speak as an individual. I live at America Boulevard, actually right down the road from where this is, where they are planning to put in retail and a higher rise residential on top of all the additional residents there. Right now, there's probably about 380 condos. That is going to balloon considerably over the next year or so, is what's anticipated. So that's just an offside comment there, that a lot of people actually use Chestnut to not only drive their cars on, but they walk also, because that's their egress into town. So first I wanted to say, I just wanted to share a couple of facts, because there have been people who've come in public meetings, whether it's Board of Health, citizens' participation, or otherwise. And I'm not here to speak either for or against. I'm a member of the Board of Health, so I'm just really not interested in taking a position. So first I wanted to share that there are a whole bunch of laws, regulations, Massachusetts general law, that the Board of Health actually is responsible for weighing in on many of the issues that we've heard here tonight. It's actually an obligation. And I want to say that it's fair to all of these individuals in this room to have that voice in front of that board, because at any time, whether it's now or in 10 years from now, anyone could come to a Board of Health hearing on health-related issues. So, and that's a general comment, not necessarily specific to anything here, but that is a consideration. And then I just wanted to give you a little feedback about the things that we have heard and been officially informed of, some of those concerns that have been brought to public participation at this mic at Board of Health meetings, or in a letter that, there was a letter that the residents had written to the town. It was dated the first week in April, and things stamped in the first week of April, but I, as a Board of Health member, received it May 18th. So.
This
Okay.
is not a Board of
Correct,
Health
but-
hearing. If the
but-
matter should be before the Board of Health, I'm sure the Board of Health will take it up in due course. I understood you were here as a public citizen, not as a member of the Board of Health. So
Correct.
if you
So
have
I just-
something to say about this project, please do so. But I don't want to debate Board of Health issues before us, because this is not the proper forum for
What I
that.
just wanted you, I was going to list the items, if you'd like to know what has been said at these public meetings or public whatever, and that letter has as a reference.
The residents of the applicant has had its say here. The residents have spoken very eloquently about their
Okay.
concerns
So-
about
so
the
then-
project.
so
And
then I
unless
will-
my fellow members of this committee wish to hear what was said before a Board of Health meeting that the applicant wasn't at and that none of us were at, I don't see where it's beneficial to us in considering what we have to decide tonight.
Well, thank you. So I won't go through the entire list, but if I may add something that I did not hear, which was portable versus permanent restroom facilities. It has been brought to my attention that there is some concern as to what those requirements are. and whether this meets the requirements. Thank you.
Thank you. Yes, sir.
Yes, good evening. Walter Hernandez. I live at 3 Columbus Avenue in Ashland. And I have two concerns. One of them is 200 Homer Ave, that building. They need that parking lot, and I don't know why they're selling it. Because I live on 3 Columbus Avenue, and there are times where cars park on my street, right in front of my house, which I don't mind, but when they sell that lot, where are those cars going? So that's one of the main concerns. The other one is, I'd like you to consider a study on what impact is going to have all that diesel running into the river before you grant it a permit. So, thank you.
Thank you.
Some brief just comments to the comments,
Certainly, Attorney Efron.
and I'll try to be on point
Thank
in
you.
order. First, to the comment by a butters counsel that we somehow are time barred to raise an argument of non-conforming use. There's been no decision by any zoning administrator or building inspector in this case. The request to file this permit was made by the town planner. I don't know if Sheila's here in her capacity as town planner by letter. We acquiesced to the request. She is not and has not been a zoning official, the building inspector. There is no time bar. So to the extent that argument was made so as to discredit the weight of that argument, it's misapplied. With respect to the buffer argument, you should understand that the position that we take in the applicant is that the bylaw 5.42 does not specifically apply to this case. We suggest it does not apply because although there is a commercial use, which this is clearly, abutting a residential use, it's an existing use. And the bylaw does not apply, I would contend, to existing uses unless those uses are changed in some significant way that would require application of the bylaw, number one. Number two, we did express initially to the residents at a private meeting before we filed anything our preference that if we dealt with that, we would prefer to do it by stipend to avoid the problems of maintaining those trees on the property to be acquired and used. A, for reasons of water transport, notwithstanding the comments that you heard. B, because there is going to be a problem, which I think you heard, with respect to the trees living and being vital. And we were invited to submit a proposal. We submitted a proposal via a spreadsheet for numbers that were done by taking the bylaw in its application and planting giant green arborvitaes, which are commonly utilized and approved by the planning board for buffering and screening, in the precise amounts of space and intervals, and then dividing up the linear footage available by each residence. That's the way the proposal was made. It is absolutely fair, as Ms. Kelly said, that they rejected our proposal and feel that they want more money. That's a dispute. I don't suggest it's within the power of your board to order us to grant a stipend of a particular amount. I know you wouldn't do that. And I don't think it's even fair to condition our ability to do this on planting on someone else's property. That has to be voluntary. It's fair to say that there's no agreement on that point. I had no conversations at all personally with the conservation agent or any member of the commission until I saw the letter that's in the record where Megan, the conservation agent, indicated, number one, it's a use permit only and there's no jurisdiction for the board, but the board would appreciate that we followed the conditions that she set forth. I called her to tell her, so she could inform whoever she wanted, that upon review the applicant thought those conditions were totally appropriate. We only got that really at the end of last week. We would incorporate it to the best we could on the plan, which you see before you, and with respect to the other conditions and incorporation of the policies, procedures, including the DEP procedures, that we would make them and propose that they be a mandatory condition. With respect to Mr. Costa, I share Mr. Costa's remarks that no site plan review is required. Obviously, and I hope you take this with some degree of common sense, as an attorney getting involved in an acquisition for a client where there's land use issues, the first thing we do is meet with staff to determine what permits and approvals we may need. We believe that we did not trigger any of the site plan review requirements. We asked for an opinion. The opinion was a concurrence by both the building inspector and the planner. Under your bylaw, we did no such triggers. Accordingly, the site plan requirement is simply the portion of the regulation of this board hearing a special permit. I suggest to you that the application was complete and the application was adequate. I don't have an enormous problem with many of the things the residents said about the impact of their neighborhood, and I don't believe any of them are misstating what they believe these impacts are. But I'd ask you to take a look and consider the things we wrote in our memorandum. Somebody's going to use these properties, and it might be us, and we might use them for parking, with or without a permit. Somebody might use them for something else, and they may come for other permits. But the fact that these things are not going to be used is just not going to happen. They're in the Neighborhood Commerce District, which allows a wide variety of uses. Yes, it is true that because of the closeness of the brook, that many of those uses will require additional special permits, as one of the speakers said, I believe the attorney, and will require some significant conservation review if and when that happens. That's not what is up for now. With respect to the curb cuts, and again, the curb cuts were proposed not by us but by staff. When I questioned staff back in March, this includes the planning board staff and the Concom agent, as to whether that would be an alteration sufficient to trigger the Rivers Act, I was told no. Because at that point we didn't think we were doing anything other than a cut into the curb, that we could go ahead and proceed. When we then went ahead and got to the DPW, talked to Mr. Small, who said, I'm not certain of that, I need further information. When that information was provided, the planner changed her position and said, you can't do this at this particular point. The applicant does not want to be forced to do that, does not think it needs to do that with respect to the adequacy of the existing access. The condition that I wrote makes it very clear. We do agree that obviously if we file for those at any point, of course we have to do that in conformity with all applicable regulations, which would include the Concom regulations, the floodplain special permit requirements. The applicant will not voluntarily, however, accept a condition that conditions its use of the property on those curb cuts. It cannot do so at this time. Thank you.
Attorney Efron, before you step down, if I understood you correctly, you said 5.4.2 doesn't apply to this case because it's an existing use, and the bylaw would only apply if there's a change in use in a significant way. Did I understand that correctly?
That sounds like a direct quote.
I wrote it down. Yeah, but with respect to Lot 2, isn't the proposed use for Lot 2 a significant change from what Lot 2 is now?
No. We actually think it's a downward change. Again, there's over 100 parking spaces there. I don't agree with Mr. Trainer's characterization that the use, the intensity of the use was really only on a one-time occasion for parked cars. This use has fluctuated along with the use of the Telecron building, number one. Number two, we have permission to park buses there from the current owner, all right? So we park there from time to time, but not regularly. There's been no limitation. There's no limitation in the bylaw. So our position really is that it is an existing use. We're not here under the tests that will strictly apply to non-conforming use, which is, the board members know, is a completely different set of standards. I actually submit it's an easier standard because that standard is you have to show an impact not substantially more detrimental to the neighborhood. Here under 9.3, you actually have to show positive impact. This is the harder standard. Mm-hmm. The other standard is the easier standard. Why? Because the law since the zoning bylaws have been enacted for many, many years, they give primacy to non-conforming uses in a manner that many people feel is way too broad, but that's just the way that it is. So our position is that they don't apply. Having said that, as you remember from the testimony, we have a 5 or 6 foot space around the perimeter, and we're putting up a fence. So it's not like we don't recognize, and again, my remarks were very careful just now, we recognize what they're saying. It's not like they don't make sense. We believe what we have put down is adequate to screen and buffer the neighbors. In addition, by moving and reorienting the buses on Lot 2 further away from that property toward the front, we've done something else to lessen, quote, the visual and operational impact. And we believe that it's within this board's discretion, at least at the special permit level, to make those rulings and findings.
One final question, if I may, on a totally different point.
Sure.
At the meeting, the meeting last time, there was a reference that there is a supervisor on the premises during the day. What are the hours that the supervisor is present?
Want me to say it? Yeah, sure. 5:30 to 9:15, and then back at 1 o'clock to 4:15.
Okay. And
can you identify yourself, please?
Yeah.
I'm sorry.
Langmeyer. I used to lived in this town since 1955. I moved out. I was a cop in this town for 35 years. I retired 3 years ago.
thank you.
Thanks, Dick.
And just for a sense of operations, the drivers come in the morning, get on the buses, do their morning routes, come back, get in their cars and leave, come back to do the afternoon routes. Is that the general manner of operation?
That's correct, but they do have some, like this time of year, it's busy because the kids have these.
No, I understand.
trips.
But typically, that's what they would do. They wouldn't be sitting in their cars all day,
No.
things of that nature. Okay. Any other questions for?
Yeah, I'd like to ask Mr. Connolly to comment about this photograph that was submitted in the last meeting, and the caption on the back said, "Fuel spilled under bus, fueling in the lot," and it was dated January 26th of 2017. I'd like to get a comment from the bus company as to what their reaction to this photograph is.
Thank you. Sullivan, who's
Thank you.
respond.
My name is Steve Sullivan. I'm the CEO of Conley Bus. So you and I talked at the end of the meeting. I asked to see all the photos that were submitted as evidence last week. So that picture is out of context. And so the fueler that we have that comes over and fuels the buses in the lot is a former Marine. I guess there is no such thing as a former Marine, but he's a retired Marine anyway. And he is one of the most disciplined people you can imagine. So today I went over and I took pictures of him while he was fueling the bus. So if I could show you some of the photos, and I can explain, it looks like there's a black spot on the ground. So the black spot is actually a plastic tray that the fueler, his name is Bob the fueler, that Bob puts under the bus, under the fuel fill, so that if anything were to spill, it falls into the tray. It looks black in the picture, looks like an oil spill, but I can show you that it's not. If I may, Mr. Chairman.
Sure.
So, there's a series of photos here that, here's the tray that, it's a black plastic tray like you put your shoes in or something when you come in from outside. Yeah, the other point is that, should I give him all? So, not only does he put the tray down, but as you can see, he puts a couple of rags in the fuel opening, so that things, if any spray comes out, it gets captured in the rag. So you can see in the picture that, he stands by the bus while it's fueling. The tray is on the ground. There's a bucket of Speedy Dry in the fuel truck, as well as some desiccant to be able, and rags to pick up any spill. So Bob is, we have 3 fuel trucks, and you can tell which one's Bob's because it's the only clean fuel truck that doesn't have any dirt on it. So when Bob fuels, he wipes the side of the bus down from the front, from the back wheel all the way to the back. Not because of this fuel spilled on it, it's just he likes the buses to look neat. So he wipes the buses off. If you go over there the day after they fuel, you'll see that all the backs of the buses have been wiped down. He says unless he knows it's going to rain the next day, then he doesn't wipe them down. So we take fueling very seriously. We don't outsource it, so we hire our own drivers. We took and we have someone who is really good at his job, and he takes it very seriously. I think the issue of fuel running into the river is, into the brook is just, it just won't happen. We have a number of fuel mitigation strategies, and we have a direct line to clean harbors. If there was ever a massive spill for some reason, the fuel tank ruptured on one of the buses or something, we have a procedure in place to be able to take care of that quickly. We've never had that issue in Ashland, but we have processes in place to take care of it. Thank you.
Mr. Conlon, could you hand back the original smaller photo there, just so I can take a look more closely?
You can see he's wiping the bus off in front in that picture that you have. He's wiping the bus off by the back wheel, which isn't anywhere near where the fuel is. So that wasn't a staged photo. That was the one from last week. So.
Perhaps this would be an appropriate time to call upon town council to give us some guidance, perhaps, on the application of 5.4.2 and whether or not it is applicable to the special permit application. Yes, sir.
Is that all? Okay. Thank you, Mr. Chairman. So the application that's before you is somewhat unique. Typically, when an application is made to the Zoning Board of Appeals for a special permit, it's for a use that doesn't previously exist, hence the request for a special permit. Similarly, when applications come before you for changes, substantial extensions to non-conforming uses and structures, the idea in those instances, of course, is that there is an existing use or an existing structure that is pre-existing non-conforming. The very concept of a pre-existing non-conforming use or structure is to be pre-existing non-conforming. It has to have been lawful when created. That's the very definition. Here we've got a use that is in existence, and by the account offered by the applicant, it's been in existence for many decades. We've got some conflicting accounts with respect to what exactly has been in use, the extent of the use, the specifics of that use from year to year, decade to decade. And you've got an application before you for a special permit. And the reason for that application, as I understand it, is that it was brought to the attention of the owner-operator that there was a need for relief. I have a concern personally, based upon my review of section 5.4.2, with the suggestion that that particular section is not applicable on the grounds that, well, we've got an existing use. As I see it, you can have it one of two ways, but you can't have it both. Either your pre-existing non-conforming use, in which case you've got provisions of the zoning bylaw that address pre-existing non-conforming uses and provide for changes or substantial extensions to those uses by way of a special permit. I would concur with what Attorney Efron said, which is that some might say that the standard for changes or substantial extensions to those non-conforming uses is actually a lesser or an easier standard to satisfy than your traditional special permit standard. Your traditional special permit standard, what you apply in this case, is that six-part test that you're also familiar with under section 9.3. For nonconformities, the test is whether or not the change or substantial extension of the use is substantially more detrimental to the neighborhood. So it's a simpler inquiry. There may be instances where that inquiry is not met, but the section 9.3 inquiry is, but usually it's the other way around. Typically it's easier to find that something is not substantially more detrimental to the neighborhood than it is to find that it meets each and every one of the 6 criteria that you've got under section 9.3. So as I see it, either you're claiming you've got a pre-existing non-conforming use and you're seeking permission from this board, again, by way of a special permit, but a different kind of special permit, a not substantially more detrimental to the neighborhood type special permit for a change or substantial extension of that use. Or you're making an application for a special permit, acting almost as if you're an entirely new use for the site. And in my mind, if you're making application under section 9.3 for a special permit, you are then required to comply with the same sorts of requirements that any other applicant for a section 9.3 special permit would be required to comply with. And that includes all the various provisions of section 5.4 concerning landscaping. Now, what's notable about Ashland's bylaw, and this doesn't exist in every section of your bylaw, and it doesn't exist in the landscaping sections of other communities' bylaws in many instances, and that is typically if you want to vary the standards of your zoning bylaw, you've got to seek a variance, hence the name. You come to the Zoning Board of Appeals, you have to meet that strict three-part statutory test to obtain a variance. You've got a provision in section 5.4, it's actually in section 5.4.7, entitled Special Permit. And it allows for the provisions of section 5.4 to be varied or waived or modified in some way at the discretion of the board by way of a special permit. Not this board, the planning board. It requires an application to the planning board for waiver of those standards. So the good news there for an applicant that is seeking to not provide landscaping buffers in compliance with section 5.4 is they don't need to meet that strict statutory three-part test for a variance, which generally would be very difficult to meet if the basis is, or what is justifying that variance request is that you'd rather not install screening or buffering. You can do it by way of a special permit and therefore subject to a less rigorous standard than a variance. But it seems to me a bit like sort of having your cake and eating it too, stating on the one hand that you're applying for a special permit under section 9.3 as if you were entirely new use, but that at the same time seeking non-conforming protections from section 5.4 to not provide the landscaping that's required without going to the planning board and obtaining a special permit. That's my read of it based upon my review of your bylaw and understanding what's been done here. But I'm certainly happy to listen to any response the applicant may have or to entertain further questions from the board.
Attorney Efron, would you care to respond?
There's not much to say. We don't agree. The other point, though, that I think is appropriate, and he hinted at it, and it's kind of important, and the historical context of how this is here is very important. Applicants signed a P&S in October. They did the due diligence. They interviewed the right people. They asked the building inspector. You don't need anything, they were told. Okay, good. Let's get ready to close. In February, the neighbors were having some tremendous problems up there, not just with us, but with other things. In the discussion of those problems, there were requests made of the planner, hey, can you get Connolly Bus Company to do something and apply for something? And she wrote that letter. I think she regrets that she did so, to be completely honest with you. And looking at the case from my perspective, as a person who was charged with representing the company who was spending a heck of a lot of money to purchase some properties for a parking use, frankly, I said, well, there is a procedure here. I don't know if it's applicable, frankly, because for other reasons, but if it's a way to codify our zoning rights, let's do it. And at least with a special permit, we're going to be able to get some significant regulatory conditions on there that'll at least be able to impact favorably the community and the neighbors, as opposed to just going ahead with our grandfathered rights. One thing Adam, I think, didn't mean to omit, because it wasn't the question that was asked, we don't have to do anything with respect to our non-conforming use unless the extent of that use is challenged. And it's not been challenged. It's not been challenged by any kind of zoning enforcement action. And only when that occurs, in that context, would we be confronted with a determination of whether or not to file for a special permit, unless we believed that the types of things we're doing there under the statute and the case law hit the criteria for a change. We don't. There's plenty of cases that talk about increased activity, increased production capacity, and in other contexts that say that without more is not the kind of change or alteration that negates this. I don't believe there is a change. We want our zoning rights, because if you have a choice between having a permit that says you have zoning rights or having nothing, you'd rather have the former, so you don't have to have an issue of uncertainty. So there's a lot of practical reasons why one applies for zoning rights, but we don't think it is an either-or situation with respect to the buffering. We believe that it doesn't strictly apply. However, because this permit is discretionary, and I would agree with that, you've got unbelievable discretion as to whether to grant or deny a permit and to oppose whatever conditions you deem as reasonable. We think it's within that discretion that you can impose whatever conditions you may want with respect to buffering, and that we suggest to you that what we've proposed is adequate.
Thank you. Town Council, inasmuch as this is my first public hearing serving as chair, we've heard the evidence. Actually, there are some things I did want to submit into the record that were documentation that was submitted to the ZBA by applicant, not the applicant, although the most recent filing today would be, but we received a letter dated May 16th, received by the Planning Department May 18th, on behalf of the Columbus Avenue Brook Street neighborhood, consisting of a number of pages. We received an email, from Kathy Edson of 20 Brook Street with a letter, the letter that was mailed to Mr. Chase on May 10th of 2017. We received an email from Julie Nardone addressed to the ZBA dated May 22nd. And then we also received the letter from the Ashland Conservation Agent dated May 19th, 2017. And I think all those should be properly entered into the record. And having done that before, I forgot to do that. Is it appropriate at this time, where we've heard the parties, we've heard the residents, we've asked our questions, it would seem that we're ready to begin deliberations. Is it appropriate, do we close the hearing and then begin deliberations? Or do we keep the hearing open while we begin deliberations, so that in the event we need to ask a question of the applicant, we can do so?
So, Mr. Chairman, it's a question that every board faces at this stage in the process, and so there are pros and cons to closing the public hearing. Certainly, once you close the public hearing, you cannot entertain any new evidence, and by that I mean matters of fact. So, if your question to the applicant required the applicant to provide additional information to you that was not already a part of the record, something that was not already shown on the first or second iteration of the plans or the submittals that have been made in writing, that information couldn't be properly entered into the record, where the record has been closed by virtue of the public hearing having been closed. With that said, it is generally my recommendation that when the board enters into full-fledged deliberations, that it do so with a closed public hearing. Not only procedurally does that make more sense, in the sense that there's no public participation at that point, but also usually by the time you're ready to engage in deliberations, it's because you believe you have all the factual information you need to render a decision to apply the standards of the zoning bylaw to the case that's before you. So we've been through 2 sessions now of the public hearing. One thing that you might consider doing is at least beginning discussions among the board members, if you intend to do so tonight, to see and get a sense from individual board members as to whether they believe they need any more information, any more facts before they apply the special permit standard or otherwise apply the provisions of the zoning bylaw. And if they do, maybe give the applicant an opportunity to submit those facts subsequent to tonight's meeting. But if there's no belief that any member needs more information, and you believe as a whole, as a board, that you have the information you need to render a decision, well, then you would close the public hearing. You need a motion to do that, a second, and a vote. And then once the public hearing is closed, you could begin deliberations, and deliberations can take more or less as long as necessary, but you've got 90 days from the close of the public hearing to issue a decision, and then 14 days to file it with the town clerk's office.
Thank you.
Mr. Trefethan?
Yes.
Before you take your vote whether to continue or close the public hearing, may I just make 1 or 2 concluding remarks?
Oh, certainly. I'm sorry. I didn't mean to...
No. I wanted to be patient so that everyone had an opportunity to speak. I just want to bring a summation that the abutters are not opposed to the issuance of the special permit. So characterization that there is that opposition is completely incorrect. What the abutters seek is that the zoning board incorporate reasonable conditions that provide for the protection of the neighbor's interests. Obviously, the applicant has provided an offer for buffering. They've provided other conditions. As I said at the outset of the meeting, the condition that the applicant at least apply for the curb cut within a date certain, and also that the plantings be incorporated. I agree with Mr. Costa's pointing out that bylaw section 5.4 is really have your cake or eat it too provision, but also you have to bear in mind that 5.4 specifically addresses what happens when there is a neighborhood that abuts a commercial area, which is why the abutters feel so strongly that the buffering requirement does apply here. And lastly, with regard to the conduct of the drivers using Brook Street and Columbus Avenue, the applicant has provided a protocol. The Exhibit A, the May 8th memorandum to the drivers, I think was just an exhibit. I'm not sure about that. I don't know if it was distributed to the drivers. But we would, again, as we said in the May 9th hearing, request that since those protocols be developed, that they be incorporated as a condition to the special permit so that the abutters do have a means of enforcement if, by chance, responses and control of the drivers are unsuccessful. Thank you.
The applicant concurs with the last comment.
Thank you. Fellow members, is there any additional information you wish to Stu?
Mr. Chairman, I'd like to ask one question to Mr. Sullivan. It might be opening a can of worms, but let's say, hypothetically, that Ashland did not have this requirement to park the buses in the town of Ashland. How would your company execute this contract? And what would be the conditions of where these buses would be and wouldn't be? And how would it differ from current conditions?
I'm not exactly sure how to answer the question. The contract, as you mentioned, with Ashland is that we are required to park the buses within the town of Ashland.
If you didn't have that condition.
So if it wasn't there, we would try to we would park them where, as close to the school department, the schools that we're going to service. So the idea is not to have a long drive of a bus from the lot to the first school or from the last school when we drop them off back to the lot again. So we would try to find a space that was as close to the schools in Ashland as we could.
But what does that mean? You don't own any land. How would you execute that?
Well, we rent that property today.
Correct.
Right. So
the current property.
The current property, yes.
Okay. If that wasn't available,
we'd be scrambling to try to find another place to move to. And once again, in your hypothetical where we don't have to find a place in Ashland, today for the next 5 years, we do have to find a place in Ashland to store the vehicles. So when the property became available for sale, it made sense to us from a business decision. So, there's been a couple of comments about when we lose the contract in 3 years. We've had it for 20 years. We will likely have that contract for a number of years going forward. When the opportunity came to purchase it, once again, Mr. Conley is a small family-owned company, and his daughter-in-law is sitting in the front row here. He's trying to prepare the company so that it continues on. So having the certainty of having a parking space for the buses, Ashland continues to grow. We're adding 2 buses in the Ashland school system for next year. So we're here as long as the contract allows us to be here.
so buying this piece of property is very, very critical to the continuation of your business, but it then precludes any other company potentially from bidding on the Ashland school contract for providing buses, does it not?
Well, they could do the same thing we would do if that lot wasn't available. We'd have to find another piece of property in Ashland to park our buses. Another company could do the same thing.
Any other questions?
Am I understanding it right that the big thing is the difference between a fence and trees buffering the lot? Is that the?
For the neighbors, I think that's true. Yes. I think we're not saying, and they're not saying, and Elaine, you can, I don't want to say what you're doing.
From the microphone,
They're not
please.
telling us to eliminate the fence and just put trees, correct?
No, we want the trees
And the fence.
and the buffer.
Yeah, and we agree with the fence and the space, but not the trees.
Okay. And what is the Attorney Costa? What is your opinion of what the legal?
Can I just say something real quick? The reason why we want the trees is, as you can see in the pictures, the stockade fence in one picture is 6 feet, and the black chain link fence is 5 feet. They want to put in a 6-foot fence, but all our houses, because of the flood issues, are all raised. So we see everything in all the parking lots, and our hope is that the trees would grow tall enough that we would not see what's going on the other side of the lot, and also to buffer the noise of the cars and the buses. We understand the buses have to test their safety alarms in the morning. We do understand that, and the trees would buffer the noise of the 120 beeps that go on every morning from 6:10 to 6:30 in the morning. That's all. We're just trying to make it livable for everybody. And trees, the fence will help a little bit, but the tree should deaden the rest of the noise that's going on enough that it's tolerable.
And the trees that you got the estimate on, are they the arborvitaes that?
I believe they were, yes. But the problem is, as you can see in the pictures, there are so many trees there that there needs to be a lot of work before anything can get planted in those places. So the cost of the trees is probably what they had in the estimate, but it doesn't have in that estimate what it would actually cost to excavate and put them in.
That's not the case, but we have different estimates. The scope of work we submit was the same, but the estimates were different, and we think the spacing was different as well.
Okay.
I think they wanted a denser tree planting, and I would too if I was them.
Attorney Costa?
So your question was about landscaping requirements?
Yes.
So I think what it all comes down to is section 5.4. And the applicant's position, I don't want to really speak for the applicant, but I believe the applicant's position, I've heard it a couple of times now, is that section 5.4 doesn't apply, or can be read not to apply, or it can be waived or varied by this board in the context of the issuance of a special permit because the use is an existing use. I don't find any support for that in the zoning bylaw. I'm not aware of any support for that in case law. My position is if the application that's before you is for a special permit under section 9.3, the applicant is required to comply with the zoning bylaw in every respect, as would an entirely new use applying for a special permit under section 9.3. And that includes the requirements of section 5.4, which mandate the landscape buffer. I do concede or agree with Attorney Efron in the statement that was made, and it's not what's before this board tonight, so I think this is important to state. But I do agree that if an application were made to the board for a different kind of a special permit, specifically that special permit for non-conforming use that I described before, where the standard is whether or not the use is substantially more detrimental to the neighborhood, that you're now playing with a different set of rules. The position of the applicant then would be that the applicant is a grandfathered use because it pre-exists zoning. The burden would first be on the applicant to establish the extent of the pre-existing use, and then either one of two things would happen. Either the applicant would continue on with that use on the basis that there has been no change or substantial extension, or if this change were determined to be a quote-unquote change or substantial extension under the zoning bylaw, there would be an application for a special permit to you where you would then have greater flexibility in terms of how you apply the bylaw and things like landscaping requirements, because the applicant would be seeking protection as a grandfathered use. Not the simplest of answers, but.
No, thanks.
It would be within our jurisdiction to grant or to place a condition that would be consistent with 5.4.2 but not citing 5.4.2?
Yes. So as the applicant's counsel has conceded, the board has great discretion and authority to condition special permits as it sees fit particularly to protect the interests that are specified in section, I think it's 9.3.2, the 6-part test.
Right.
And so as you apply that test, if you determine, and I've heard a number of things referenced tonight concerning points of access, concerning fencing, concerning operation plans, if you determine that to meet any one or all of those 6 criteria, that certain conditions are required, everything from that there be an operations plan, that traffic be directed in a certain direction, or that there be landscaping, that would be within the board's authority to include as conditions of the issuance of a permit.
Would it also be within our authority to prohibit buses from operating on a particular public way, such as Columbus Street?
So it's challenging when it comes to prohibitions that are not accepted by an applicant with respect to the use of what are public ways, because the use of public ways is not a matter that's within the jurisdiction of this board. However, when an applicant makes an application, be it for a commercial parking lot or for, and I can think of a few other examples in Ashland, matters that have come before your board in years past, come before the planning board, issues of commercial uses, drive-throughs, and where access is going to be to and from, what roadways adjacent to these facilities will and won't be used, left turns, right turns. When an applicant is in agreement with those sorts of conditions and is committing to a condition that would specify the direction of traffic, or that no traffic enter or exit from particular locations, certainly you can include those as conditions. And the general rule is if it's not challenged on appeal and your 20-day appeal period runs, that's an enforceable condition.
Any other questions? Brian?
Yes, the attorney for the neighborhood people, you keep talking about asking as a condition for the curb cut to be asked for within 30 days, or?
By a date certain.
By a date certain.
Since this board has no control over any other board.
And how does that affect what they do? Why do you want that?
Because if there is no requirement, then it may never be done. And the reason for that is that because this is within a protected zone under the Rivers Protection Act, within 200 feet of the Sudbury, any breaking of the deliberate breaking of the pavement is going to trigger 2 requirements. One, Conservation Commission supervision, and second, probably stormwater management, because of the increasing requirements of those protocols by DEP. So since the applicant's counsel has stated that the applicant is in wholehearted support of doing the curb cut, what we suggest is that the board say, okay, we'll accept that. We know we can't make other boards give you a curb cut, but we do want you to make a good faith effort to at least get one in order to alleviate the traffic from Brook Street and Columbus Ave.
So what happens if they apply for that and they can't get it?
At least they've made their good faith attempt, and we think that that's a reasonable condition within the special permit. You can't require them to get one if the boards won't grant them, but you can require them at least to make that first step in order to meet what they're saying at this hearing.
Ma'am?
Yes.
I think I heard Attorney Efron say that when they decide to get one, they would comply with all of the requirements.
Right, but that's not a finite commitment. When they may decide to do it in 5 years or never. So if it is their intent, at least have them apply by a date certain. Make it within the year if you wish, but nevertheless, I think that Attorney Costa can speak to whether or not it's within your power to place that condition, and I think that it is.
But if we put that in our own conditions, and they decide at some point in time in the future, the town has a record of this decision of our board for the applicant to go through that process.
What I'm saying is, as a condition of the special permit, apply that the applicant has to apply within a date certain for the permit in order to get a curb cut, which I think would require Planning Board, Concom, and DPW review. If that's done, if that application is made, regardless of outcome, that condition is satisfied.
Confused.
It's just the application.
Attorney Costa, could you perhaps?
I can try try and paraphrase or rephrase or say it differently. I think that what council is suggesting is that you certainly can't require as a condition of a permit issued from this board within your limited jurisdiction that an applicant obtain other permits and approvals, because you have no jurisdiction over those other permits and approvals. And if they're unable to obtain those, that's essentially a de facto denial of the permit they've sought from you because it's a violation of that condition. That's what council is conceding. What she's suggesting, however, I think, is that if the board were to include a condition in its approval, should it see fit to approve the project, that would require application be made for all applicable permits and approvals to allow for that access onto Chestnut, that secondary access onto Chestnut, within a time certain, be it 30 days, be it 90 days, be it 180 days. It requires the applicant to take affirmative action within the next 30, 90, 180 days to begin to pursue that permit and approval. I think her point is there's a statement that's been made that the applicant wholeheartedly supports that access, but if you issue a condition, if you issue a decision without a condition that specifies that any action be undertaken to pursue it, and you approve a plan that doesn't show the access, the applicant might have just stated that for the record and then ultimately make no effort whatsoever to pursue a potential curb cut.
Thank you.
My comment and my recommendation to the board, I've got no issue if the board sees fit imposing that sort of a condition. Certainly Attorney Efron can respond to what he believes its appropriateness or inappropriateness is. I do think that the board needs to justify, as with any condition, its basis for including that sort of a condition. So is it within the board's discretion to include a condition that within X number of days or months or years and an applicant, a permittee, make application for a different permit or approval and see it through to the best of their ability? Sure. But that condition needs to be justified by the standard that you're applying. And so I think the question one of you asked was, of council, was, you know, why is it necessary? And she answered why it's necessary that this condition be crafted as such, but is the additional access onto Chestnut Street necessary? Is that additional point of access a necessity because it's been eliminated from the current version of the plan? If the board believes it's necessary for safety purposes, for ease of circulation, for alleviation of traffic on some of the secondary roadways as was suggested, those are potential bases for that inclusion of that sort of a condition. Those fall within the types of considerations the board can make under section 9.3.2. But if the board doesn't believe that there's a circulation issue with the project as designed here, doesn't believe that with other conditions or otherwise there's going to be unnecessary traffic on secondary roadways, well then maybe it's not a justified condition. That's for your board to decide.
Yeah, and that's exactly right. It is entirely within this board's purview to make that determination.
So if the applicant gives up the idea of a curb cut, any curb cut in the future, we don't have to consider that, correct?
What do you mean by gives up the idea of any curb cut?
Let's say they withdraw that requirement in their proposal.
Well, I don't think there currently is any sort of a requirement in their proposal. I think that there was a statement made at the first session of the public hearing that the applicant, and I'm quoting third hand, wholeheartedly supported or supported in some respect the addition of a curb cut onto Chestnut Street. We now see the second iteration of the plans and that's been removed, and you now see striped parking where that curb cut was, although the curb cut is still sort of shaded as a potential future curb cut, but they're not proposing that as part of the plan that the board is being asked to approve. So if the board approves the plan as shown, you're approving a plan without a curb cut onto Chestnut, other than the existing curb cut for Brook Street.
That's what I think we should do.
I think Mr. Siegel, I'm sorry. Mr. Siegel, the first time he asked the question, we had it right on the nose. Proposed condition 1 says, the project shall be limited to the improvements shown on the site plan. The improvements shown on the plan and labeled possible future curb cut on Lot 3 and curb cut on Lot 2, showing a proposed new access from each such lot onto Chestnut Street, need not be constructed and shall not be constructed unless and until any and all other approvals and permits, including any such permits from the Ashland Planning Board and Ashland Conservation Commission, as may be applicable, are received. That is the applicant's proposed condition. It should not come as a surprise to you that I don't know what a good faith attempt is to apply for a permit, but I can tell you I know how to get denied a permit pretty easily. very easily, okay? You go up, you make a showing, it's not adequate, you get denied your permit. It's much easier to get a permit denied than a permit granted. And these types of permits require an enormous expenditure of monies for engineering studies that have not been commenced nor contracted for, to study both drainage analysis, stormwater analysis, the brook, the flows, the effect of the proposed construction, requests from waivers because there's no buildings. It's a complicated and lengthy process. So when I said we wholeheartedly support it, yeah, we wholeheartedly support it if the requirements that are applied because the town joins us in that application because they think it's an improvement of what is essentially an access onto their public way, as opposed to something that the applicant definitely wants to contract to do with a specific time, when we don't believe it is necessary, as Attorney Costa said, for the safe access and egress to and from the lot. And I don't think this record is replete with evidence that shows that there is going to be a problem with access to or from the lot.
Just addressing that for a moment, you referenced the future curb cut on Lot 2, but if I understood correctly from the engineer's answer to my question earlier tonight, the revised site plan that's submitted today does not have a proposed future curb cut.
You're 1,000% correct. Attorney's stupid. When he revised the conditions today, he didn't revise paragraph 1. The only thing that shows on Lot 3 is the only curb cut that's shown is Lot 3. The reason it's shown is that theoretically, if we got all of those other permits at some point, whether you include it as a condition or not, we would be able to utilize that curb cut if drawn and shown exactly on the site plan without having to come back to this board to amend the special permit.
Thank you. Any other questions? If not,
Well, I have another question.
Yes.
So how many buses leave when they leave in the morning? Do all 69 buses go out at once? Or what's the typical?
I can help. Hopkinton is further away, so we have to leave earlier. Okay? Most of the buses are out of there by 6:15 in the morning.
What's most in a number?
27 buses.
Okay.
Ashland goes later. And they got, how many got? 14. They got 14.
So 27 pull out at a certain time? No?
It varies from, like you say, we've got 2 buses going out at 5:30 in the morning. They don't have to go at 5:30. We can go out at 6 o'clock in the morning. It's just a case of, I used to drive that bus. I come from Upton. I go down, pick up the bus, take the bus out of there, look at TJ's, have a cup of coffee, I know the guy up there, and I leave from there and I go to Upton. Bus. There's only 2 buses.
I'm just trying to figure out how many buses pull out like in at one time.
It's a staggered number. In other words, 6:15 we all gotta be out of there by 6:15. The 27 buses gotta be out of there by 6:15. I mean, 6:15.
And what time do you start going out? 5:30? So 45 minutes?
So we have 2 buses that leave at 5:30.
Stand up, please.
I'm Stephen
Identify
Connolly.
yourself.
2 buses that leave at 5:30, and as Dick said, they're staggered going out depending on where the bus is going. So the furthest point in Hopkinton, the bus is gonna leave earlier. Now, the Ashland buses will go out a little later because of the bell time. So the furthest bus that's going to the furthest point will go out first, and the closest buses will go out after that. So in your morning, you have your Hopkinton buses leaving early at 5:30 is the beginning time, and then Ashland leaving, and the later buses are probably right around 7 o'clock.
And your name?
Stephen Connolly.
With the changing of the Ashland school starting time next year, I believe that's going to happen. That will impact you also.
Well, the buses will leave a little later.
Okay.
Right.
That's what I wanted to get out there.
Yes, yeah, that's next year.
Okay, next year.
But to answer your question, the big chunk is from about 6:05 to about 6:35 that the buses are leaving.
okay, thank you. Any further questions? If not, it would seem to be appropriate for a motion to close the public hearing.
Mr. Chairman, I move that we close the public hearing on this application.
Is there a second?
I second that motion.
All in favor? Aye. Opposed? Abstained? Moving on to deliberations. Appropriate at this time, council, to identify the members that are sitting on this matter?
Well, I think that makes sense. So we've had 2 sessions of the public hearing, and we've had some inconsistency in terms of the members who have been present, which can often occur. I presume, and maybe I shouldn't presume, that deliberations may go beyond tonight. It would certainly be my recommendation that if particularly if the board sees fit to approve the project, maybe less so if it's going to deny the special permit request, that you not ultimately vote on that approval until such time as you have a decision before you with all the various conditions, as has been the board's practice in the past. But certainly you can begin deliberations tonight and continue those beyond tonight if you so choose.
Okay. Very good. If I recall correctly, at our first hearing, the members and associate members who were designated to sit on this hearing were Brian Forrestal, Simitri, who is not here this evening, and myself, so that we need to appoint or name a third member to sit on the matter. Tom, who was a full member, was not present during the hearing last time. Mr. Siegel was present both last time and this time, so it would seem to me it would be appropriate for Mr. Siegel to step in. Is that acceptable to everybody?
For me.
Okay. Very good. Well, shall we start our deliberations? Who wants to go? May I suggest perhaps it makes more sense to talk about whether or not to grant the special permit for use or to deny the special permit for use, because certainly the need for conditions is not applicable if the application for special use is denied. You want to take our initial roll call vote on that? I mean, I'll gladly start the process rolling. And first, what I would like to say is I want to commend the applicant, but I also especially want to commend the neighbors. The amount of work that has been done by the neighbors and the neighborhood in addressing the issues this application for special permit presented, the time and effort spent in meeting with the applicant and the applicant's attorney, attempting to come to some common ground on the issues. I appreciate, speaking personally, very much. It's made our job somewhat easier, although I think it's still a very difficult job in this instance, to address the many issues that the neighborhood faces. And I do want to sincerely thank you for the efforts put forth. It's identified a number of areas of common ground. I want to thank the applicant, because clearly not every applicant that comes before this board or other boards in the past has tried to work with the neighborhood to reach some accommodation. It's not always possible, but the effort was greatly appreciated by me, and I'm sure I speak for the other members of the board. My position on this, looking at the application and setting aside the issue of conditions, is that on this property it's been used as a parking lot for a long period of time. There can be some debate about the exact number of years and the full extent of the use and what vehicles were parked where and when, but it's clearly been a parking lot for school buses for a period of time prior to the institution of the zoning use ordinance. And my feeling and position on this would be to grant the special permit for use, but with a number of conditions, some of which have been agreed to basically by the applicant and by the neighborhood, and perhaps the imposition of some other conditions which neither the applicant nor the neighborhood might be fully in favor of. Having said that, Brian?
I agree. I am inclined to grant it, but with a number of conditions.
Stu?
I also concur with your summary, John and Brian. The only question I have is that several residents have made a concern that other committees within the town might want to comment on this. Like there was a comment by Mr. Morgan, I'm sorry, about the Concom committee voicing their opinion about potential wetland issues or not. So how do we address that?
Well, I think as we do in any decision, there is a general requirement that the applicant comply with all laws and bylaws of the federal government, state government, and town of Ashland government. And I think it's not up to us to invite the Conservation Commission to weigh in on this, or to invite the Board of Health to weigh in on this, or the Planning Board to weigh in on this. Those boards will deal with whatever issue involving this project may be within their purview, if, as, and when such matter is brought forth to them. And if there is something that's not being done appropriately, then the zoning enforcement officer would have an opportunity and the obligation to file a complaint and a procedure and come back before the appropriate entity for relief. So it sounds like we're all in agreement to grant the special permit, and now we get down to the easy job of conditions.
Okay.
Let me start, if I may. What I did was the applicant in its application and again in its letter accompanying the revised site plan today had proposed a number of conditions to the special permit, which, as Attorney Efron usually does in his matters before us, I have observed, tries to help the board along in our deliberations. The neighbors responded, and their counsel responded to that in writing as to whether they agreed with certain of those conditions or not. And what I did was take the 14 conditions that I had, but it looks like there are 2 new conditions because now the list submitted today has 16, so we'll find out what the other 2 are and see where there is agreement. And if there is agreement, then it may be that those are appropriate conditions for us to impose upon the special permit. Does that sound? Sure. Okay. Item number 1, and I'll read them as we go through because I think we should probably take perhaps a vote on each condition as we go, or at least a consensus that we know what we're going to do on the condition. Number 1 was that the project shall be limited to the improvements showed on the site plan. The improvements shown on the plan and labeled possible future curb cut on Lot 3, strike out and curb cut on Lot 2, showing a proposed new access from each such lot onto Chestnut Street not be constructed and shall not be constructed unless and until any and all other approvals and permits, including any such permits from the Ashland Planning Board and Ashland Conservation Commission as may be applicable, are received. And if I may, after having read that, let me just set that aside because that's one where there is not agreement on between the neighbors and the applicant, so I immediately violated what I said I would do. Going to number 2, which is the first item of agreement. No buses exiting from Lot 3 as shown on the site plan. And by reference to the site plan, I'm referring to the revised site plan that was filed today, shall make a left turn onto Brook Street. Any comments on that? Everybody in agreement that that would be an appropriate condition? Okay.
I think.
Number 3, no buses or cars exiting from Lot 2, as shown as the revised site plan, shall make a right turn onto Brook Street. Comments? Agreements?
I agree.
Number 4, applicant shall install clear and conspicuous traffic signs to direct all bus and car traffic down Brook Street from both lots comprising the property towards Chestnut Street. Any question?
I agree.
Agreed? Number 5, the applicant shall require its employee drivers to adhere to the protocols attached hereto as Exhibit A. Applicant shall not make any material changes to these protocols which may adversely affect the surrounding neighborhood. In agreement on that one?
Yes. Yep.
And by Exhibit A, the document that is referred to is a memo to all Ashland bus yard drivers from Stephen Connolly, Operations Manager, dated May 8th, 2017, regarding new protocols for school bus parking lots, consisting of 2 pages. And I would note that on the second page is a reference that Columbus Avenue shall be avoided completely, personal vehicles and buses. Number 6, parking shall be limited to school buses, employee drivers, and employees exercising managerial and supervisory control over the property. In agreement on that one?
Yes.
Number 8.
Skip one?
Well, I skipped number 7 because I didn't think that was in agreement, and perhaps number 8 and number 9 also may not be in agreement. Number 10, other than routine maintenance, i.e. checks for leaks, fluid checks, wiper and bulb replacements, and repairs to mirrors or other mandated safety equipment, no oil changes or other vehicle repairs shall be performed on the property. All bus repairs and non-routine maintenance, including any engine and body work, shall be performed at the company's maintenance facility located in Walpole, Massachusetts, or at another off-site location. Any change on that? Everybody in agreement? Number 11, the required school bus backup alarm shall be activated only, parenthesis 1, close parenthesis, during mandatory pre-trip inspections, and parenthesis 2, close parenthesis, when parking as the buses back into spaces at the end of the run.
I agree.
Agreed. Skip number 12 for the moment. Number 13, idling of buses and cars shall be subject to applicable legal requirements set forth in General Laws, Chapter 90, Section 16A, and 30 CMR 7.11. In agreement on that one?
Yes.
Okay. So now let's go back to the, excuse me, one more. Item number 16 in the list of conditions proposed for today. Applicant shall conform in all respects to the conditions set forth in that certain correspondence of the Ashland Conservation Commission dated May 19th, 2017. In agreement on that one?
Yes.
Okay. Going back to item number 1, which I have previously read, but that had to do with the future curb cut on Lot 3, and that it need not be constructed as it's shown on the plans, and shall not be constructed unless and until any and all other approvals and permits, including any such permits from the Planning Board and the Conservation Commission as may be applicable, are received. Discussion on that. Obviously, we've heard the request from the neighbors and the Neighbors Council. requesting that the applicant be required within a certain time period to file such an application. And we've heard from the applicant's counsel that it was not in agreement on that issue, and as Attorney Efron phrased it, and not quoting him but paraphrasing, he knows how to get an application for a permit denied. Thoughts on that?
I personally think we should eliminate all references to curb cuts on parking lot 2 and parking lot 3, and it would make our life easier.
Well, the eliminating curb cut on lot 2 has already been done because the revised site plan that was filed today does not contain a drawing for a proposed or a possible future curb cut. So I think that one has been eliminated. The question comes down to lot 3.
Well, the functionality of the plan, if it were to go into effect tomorrow, the applicant is not saying that they require a curb cut on lot 3 to operate. So if they currently don't require it, let's hold them to it.
Well, I think just following up a little bit on what Town Council has advised us is that if we were to place such a conditions concerning curb cuts, there would have to be some basis in our determination for leaving traffic on Chestnut Street. And frankly, the distance between the curb cut, proposed curb cut, and Brook Street is fairly small, and I'm not sure what additional improvement to traffic on Chestnut Street there would be by requiring such an application be filed within a certain period of time. I guess my thought is, if we were to put in such a request or requirement, say 180 days or 360 days, obviously it would rely or be reliant upon the applicant's good faith going forward with that and submitting an application which would have all the necessary documentation to submit, and I'm not sure we could condition any approval upon conditions such as that. I think Stu's point about perhaps not referencing curb cuts, other than putting in a statement that if recognizing that there's a plan, that the plan has a potential curb cut on it, but requiring them to get all necessary approvals would provide us with protection on that. I guess that's where I'm coming from.
I think it goes without saying that if they're going to do a curb cut, they have to get all necessary approvals.
Correct.
But us putting it in as a condition that they apply for one, Attorney Efron's already made it very clear that that has no teeth and is not worth mentioning. You're going to go up and say, can I get a permit? They'll say no, and what's the point?
I hope I do better than that.
Well, I dumbed it down.
I was trying to be
Yeah.
as candid as possible.
Yeah.
Always appreciated, sir.
Yeah. So I don't see the point in adding anything about curb cuts that has no teeth in it.
Well, if there's not a reference to a potential curb cut on the site plan in our decision, if the applicant were in the future to seek a site plan or seek a curb cut, they would have to file a new plan before a different agency. Would they not, Counsel?
So I think that what the applicant is attempting to do by virtue of the filings that they've made in this case is maybe short circuit that requirement. So typically your site plan is approved, be it by the planning board or the zoning board of appeals, and anything other than a minor or insubstantial modification, something that is a consequence of construction in the field would require a modification before that same board. I think I even heard Attorney Efron say that by virtue of showing the detail of the proposed future curb cut on the plans that have been submitted today, the idea would be that if you approve these plans as is by specific reference to them, if they opt in the future to add the proposed future curb cut, there would be no need to come back before this board for a modification unless you were to state otherwise in your decision, because of the plans that have been submitted and the statements that have been made on those plans and the showing of the proposed future curb cut. So that addresses your question with respect to dealings with this board. Certainly, if there are other permits and approvals required from other boards, commissions, committees, those applications would need to be made and those permits would need to be obtained. That's nothing new. Often applications that come before your board require planning board approval, Concom approval, Board of Health approval, and that's why you've got that condition that I think I drafted 5 or 6 years ago and has found its way into most every decision since, that essentially says subject to any and all permits and approvals required from any board, commission, committee, and then sometimes even go so far as to specify the ones that you know are forthcoming.
But if we mention it, we have to put a date on it, correct?
If you mention what?
Potential curb cut.
Well, if you go the route of what I think Attorney Efron is asking you to do, which is to not mention it, do whatever you choose, but approve these plans that show it as a proposed future curb cut, you're essentially giving permission, or he would argue you're giving permission, for that curb cut to be added in the future, if the applicant so chooses, or not. But if it is added without coming back to your board to modify the plan, because the plan shows that that curb cut's going to be made. That's a very different question than what counsel for the neighbors, or several of the neighbors, had indicated, which was this issue of, should you force the hand of the applicant? Should you require that the applicant pursue this permit within some detailed time frame, in good faith, diligently, whatever? That's a different question.
So I'm okay with them having the proposed curb cut on this plan if they so choose to do so in the future. I don't think they need to come back before this board for it, but they will have to seek approval from all the other spots in town.
So there would be just, the condition would just be the project shall be limited to the improvements shown on the site plan.
Yep.
Period.
Stu? Period.
I can buy that.
Okay, I'm fine with that. Item number 7. Thank you. It's all right, I was just looking to make sure 6 was also covered, and it has been. Parking shall be located and utilized as set forth on the site plan. There shall be 60 school bus parking spaces on no car parking spaces.
And, should be and.
And no car parking spaces on Lot 3. Thank you. There shall be 9 school bus parking spaces and 61 car parking spaces on Lot 2. All parking spaces shall be striped. The revised site plan that was submitted today does show that on Lot 2, the location of the 9 school buses has been changed from the side to the Chestnut Street entrance, or the Chestnut Street side of the parking lot. Any questions or comments, problems with that, as proposed by the applicant as a condition?
No, Stu, did you want to add that the snow disposal area be striped for no parking?
Striped diagonally to not encourage parking.
Yeah.
Okay.
Guys okay with that?
I think that would be very appropriate.
Yeah, let's add that.
Item number 8, a sanitary porta potty to be serviced by contract with the vendor will be located as shown on the site plan on Lot 2 for use by the company's drivers. The location of the porta potty has been moved in the revised site plan so that it is now
Yeah, closer to Chestnut Street and off
Yeah,
of
it's going to be closer to Chestnut Street and Brook Street and further away from the neighbors, and that next to it is the proposed dumpster, which is the subject matter of condition number 9, which will be used for the depositing of trash from daily bus sweeping and any driver personal trash. And it's also noted on the site plans, and I would suggest we should make it part of a condition that both the porta potty and the 4-by-6-foot dumpster be surrounded by a 6-foot high wood stockade fence to shield it from the general public.
3 sides, right?
I'm sorry?
3 sides?
3 sides.
Yeah.
Is one sufficient?
Well, my thought on that is that is an issue that is not a zoning board of appeals issue, and that if there is another entity in town that has a disagreement with that, then the applicant would hear from them, and the applicant would have to make its peace with them. Works.
Mr. Chairman, on number 9, I don't know if we could potentially ask for another condition for the dumpster contractor to maybe, I don't know what their schedule is for emptying the dumpster, but let's say it's weekly. To ask them maybe every 2 weeks to just do a quick policing of the area, to maybe pick up some of the trash that might blow on the fence for the abutters, because there was a complaint that trash is.
I know it shouldn't speak, but the dumpster contractor will not do that for us.
That's what I was.
If you're gonna do something like that, you have to impose it on the applicant.
That's what I was going
Sorry.
to. That's what I was going to say.
Okay. Well, I think something should be done.
Well, I think my thought would be that we could address that in a separate condition, because I'm going to suggest that we not only apply the conditions suggested by the applicant, but there may be some others that we have thought of, or that the neighbors have thought of, that we could also apply. But I think as part of the trash pickup, that could certainly be included in one of those, because I think the dumpster truck will come in, pick up the dumpster, dump it in its truck, put it back down with its crane, and drive off. I think it might be appropriate to list appropriate hours for the dumpster to be moved, and I would suggest no earlier than 8 a.m. and no later than 4 p.m.
I've never seen them.
I think that's an appropriate condition. I think that's any thoughts on that?
From other matters, that's a good idea.
Thank you.
Can you repeat those hours?
8 a.m. to 4 p.m.
Thank you.
Oh, I would think you also want it to specifically be done during the time that there's no bus traffic zooming in and out.
Well, that,
Pardon me?
That's certainly when it's
that
done.
can
It's
be,
not done while we're
yeah,
here.
then they can, the applicant and
They
the-
know that, though?
I think the applicant and vendor can
Okay.
work that out. Item number,
12.
actually, I don't think, did I read number 11, the required school bus backup alarms? I did,
Yep.
okay. Number 12, having to do with snow storage, shall only be done in the areas marked on the site plan, and I'm reading now from the proposed conditions. As snow disposal area, stockpiles of snow shall not exceed the height of the wood fence to be constructed on the property perimeter. Any snow in excess of such limitation shall be transported off-site by the applicant. I know that with respect to the original plan, the neighbors had some concerns about where the snow would be stockpiled. The site plan filed today changes in some respects the locations of the site plan. Any thoughts on any further restrictions with respect to the snow disposal areas, which are all located in Lot 2, with the exception of one on Lot 1 along Chestnut Street and second one on Lot 3, rather, along the back of the property abutting the neighbor.
They're gonna keep it at a 6-foot height.
Yeah, the restrictions would be a 6-foot height, and otherwise it would have to be moved. And this might also be an appropriate time for, I liked Stu's idea of the striped demarcation lines for the snow disposal areas, so to discourage parking. To me, that seemed like a reasonable condition. And perhaps not as part of this, but there was a reference at our last meeting, and the engineer addressed it briefly in tonight's meeting, but that the site plan talks about grading to a drain on the rear of Lot 2 that abuts the Kelly and Lamberth and Korea properties as noted on the plan, and also the Trainer property, although my thought would be a condition to require the lot to be drained away from the neighbor's property, so it goes into the drain located within the lot.
It's on the plan, it says
Yeah,
grade to drain.
so as long as, but I think for that it should be, I think I'm more comfortable making it a specific condition and not just a general site plan or condition as listed on the site plan, if that's okay.
17?
That was the condition to eliminate that minor flooding.
The flooding that was noted by the
abutters.
By the abutters. Moving on to item number 14. Applicant shall install and maintain the wood fence around the perimeter of the property as shown on the site plan. Such fence shall be of solid wood, either white or natural color, and be 6 feet in height. Now, on the site plan, what is shown is that the wood fence is basically between the parking lots and the abutter's property, and that a chain link fence would be maintained on Brook Street and on Chestnut Street as presently exists. With respect to the 6-foot-high wood stockade fence, any questions on that? Any thoughts on that, or are we in agreement that that would be an appropriate 6-foot-high wooden stockade fence be placed there? Stu?
No. I think you have to decide, is it going to be natural? There's a choice here. Is it going to be white or natural color?
Okay, what would you think would be most appropriate?
Natural.
Thank you, Stu.
Yes, natural. White means you have to repaint it.
Yeah.
Well, then you can put in a vinyl fence.
More appropriate. Natural color, okay?
Natural sounds good to me.
Okay, natural color sounds good. Let's move on to item number 15, and we'll come back to the issue of landscaping, if we may. Number 15 is applicant shall repair, and again, this is a condition that was added in their letter today. Applicant shall repair any portions of the chain link fence on either lot running along Brook Street which are in disrepair. I drove on Brook Street today, and to me, it looked like the entire chain link fence was in disrepair on Brook Street.
Both sides?
Both sides. And I would think an appropriate condition would be to replace the chain link fence on Brook Street with a new chain link fence.
On both sides?
On both sides. Both abutting Lot 2 and abutting Lot 3. Now, they can't comment because we've closed the hearing, so I'm looking to you for your thoughts.
I concur.
I agree.
Okay. With respect to trash, and I'm jumping around a little bit because I'm leaving the landscaping, which may be the most difficult, to the end. With respect to trash, we saw the photos of the trash, and that it appeared certainly that some of the trash and some of the leaf material were inside the property lines and some were outside the property line. My thought would be that we could certainly impose a condition that requires them on a weekly or bi-weekly basis to clean along the fence area inside their property and to maintain their property in a reasonably clean condition, and that perhaps we could require, and that they would agree as a sign of good faith, that at the time they replace the chain link fence, that they also remove the leaf debris that's on the outside in the street area that's trapped up against the chain link fence, because that presumably would have to be removed before a new fence could be installed. Thoughts?
I concur.
Brian?
So clean up that whole...
Just clean up along the fenced area on...
Is that
Brooksy.
their property or town property that we're talking?
The street would be the town's property, but the leaves, as we saw from one of the photos, leaves have blown up against and are trapped up against the fence.
So what is the condition going to say?
It would be a one-time that they clean up the trash, the leaf material trapped up against the fence. I'm not suggesting that they be required to clean the entire street. I think that would be unreasonable. That's the town of Ashland's obligation.
Yeah.
Would you want that as part of condition 15?
Yes. I think that would be a good spot for it. Now, the issue of the buffer zone. We've certainly heard a lot of legal definitions as to whether 5.4.2 applies or it doesn't apply, and what 5.4.2 requires. Just for everybody's purposes, with respect to 5.4.2, such screening shall consist of a landscaped area at least 6 feet wide and shall create an effective visual barrier from ground level to a height of at least 5 feet. If I understand correctly, the applicant has suggested that any buffer materials such as trees and shrubs be placed on land owned by the abutters. The abutters are seeking the trees and shrubs be applied on the applicant's property if they acquire it. The bylaws also, and strike that, if I recall correctly, the applicant talked about arborvitae is approximately 10 feet apart, and I believe Mr. Trainer, in his talk or statements last meeting, talked about emerald green arborvitae placed 5 feet apart, which would seem to be, according to Mr. Trainer, providing a better buffer zone. I would note, in following along with our zoning ordinance of 5.4.2, buffering between residential and non-residential uses, there is a reference under 5.4.3 to buffer areas, and it describes what type of materials can be used, and there's a reference in a neighborhood commerce district. The buffer strip shall include evergreen plantings with at least one tree for each 10 feet of buffer length as measured parallel to the property line, which may be where the applicant's proposal came from. And it references that there should be a maximum mixture of 75% evergreen and 25% deciduous trees, which are visually impermeable within 2 seasons of growth. So that perhaps gives us some outline of the perhaps parameters that we would be dealing with when we decide what condition, if any, to place on landscaping. And I'm assuming that there will be a condition. First, let's talk perhaps about the issue of whether to make a condition that the landscaping be applied on the applicant's land or whether it be applied on the abutter's land. To me, it seems as though the buffer zone would have to be applied to the applicant's property. I don't really see how we can require the applicant to place a buffer zone on someone else's property. Adam, would you have a thought on our legal ability to require that?
You can't.
Thank you. And that sort of simplifies our discussion.
There's a challenge that exists, and I've seen negotiated resolutions of cases, often with fewer neighbors, smaller properties, where there's 1 or 2 neighbors that are affected or most affected by a proposal, and there is some agreement between those neighbors and the applicant before the board, and so the board will include a condition based upon representations made at the public hearing, both by the applicant and by those neighbors, that they're in agreement that there shall be a landscape buffer of X feet with certain types of plantings that would be on a neighbor's property. Typically, that's done by way of some funding provided to the neighbors, because often the applicant doesn't want to incur the liability of going onto property it doesn't own to install plantings. In a circumstance like what I think we have here, which is there's been attempted negotiations, but there's been no resolution achieved, the board's in a difficult position, because certainly you can't require as a condition of a decision, unless it were stated to you at a public hearing that the neighbors were in agreement, that they were all in agreement that there would be allowed planting on their property. You can't require that as a specific condition of approval. You can get crafty with how you word a condition, if you so choose, to allow for compliance as nearly as practical with requirements, for example, of your zoning ordinance, through the provision of fencing, screening, buffering, either on the subject property or on neighboring properties per agreement with individual neighbors. I mean, I've seen conditions that have been drafted in such a way that they try and achieve that purpose, but you have to be sort of vague, because you can't impose restrictions as part of an application, a decision that pertains to the subject property and its chain of title, on other properties that are not presently before you, other applicants, other property owners that are not presently the applicant or before the board.
Thoughts?
So we have a condition where we're gonna have a fence. We know that, right? Now, we have to decide on, you know, what goes in front of the fence and on what side of the fence. If I heard Adam correctly. So we're saying that we could maybe leave it up to have an option to say if someone, if an abutter wants to in private say, I'd like a plant on my side, we could do that, or the plant's gonna go on the applicant's side. I mean, we have to, you know, make that decision. So do we know that every abutter just doesn't want a plant on their side, or do we leave a timeline open for them to submit a request to the town office, or the planning board, or to the planning office, or
I think that would not be appropriate. My sense from listening to the neighbors was that it seemed as though they were unanimous in their feeling that there should be a buffer zone on the applicant's property.
Okay, so
Brian,
that's
what's your memory?
Yeah, I agree. They all want trees on the applicant's property.
Okay.
What I heard.
And I think that's, my suggestion would be that as a condition, we require that there would be a buffer area consistent with what is required under that.
5.4.3.
Well, I was not going to refer to the specific statute, but that we require that there be a 6-foot wide buffer area, and that trees, evergreen plantings, 1 tree for each 10 feet of buffer length, and a maximum mixture of 75% evergreen and 25% deciduous trees, which are visually impermeable within 2 seasons of growth, be applied as a condition. Would that be within our authority to do?
It's certainly within your authority. The challenge becomes consistency with the site plan that you're approving. So, and we've come across this in Ashland. I've certainly come across it in my dealings with other boards where they impose conditions, but in order to comply with those conditions, the site plan needs to be modified, and sometimes modified in such a way that though it may seem to be a minimal modification in the board's view, it ultimately throws everything out of whack on the site. You're obviously dealing with a pre-existing site here. Conditions are rather tight. Number of parking spaces, maneuverability, a shift of something a few feet in one direction or another could really affect the entire layout of one of these sites, I would think. I'm no engineer, but that's my sense based on many years of reviewing plans of this sort. So to require a 6-foot wide buffer zone wouldn't be too much of an issue as I see it on Lot 3, particularly on the westerly side of Lot 3, because it looks like you've got an approximate distance between the property line and the start of the bus spaces of 7.7 to 7.8 feet. So you've got enough area there to erect a fence and still have approximately 6 feet of landscape buffer. You don't have that same area consistently, or continuously, I should say, along the westerly boundary of Lot 2, along the properties of Kelly, Lamberth, and to a lesser extent, but to some extent, Trainer. You don't have 6 feet of width there on the applicant's property to be planted. So if you require, as a general condition, even along just those properties, let alone some of these other side yards, a 6-foot wide buffer, you are essentially requiring either reconfiguration of the site to the extent it's feasible or loss of parking spaces. I'm not saying you shouldn't be comfortable with that, but I just want to make you aware of what the consequence of a potential condition of that, like that, could be.
Where the application of 5.4.2 to this project is in dispute, would it be within our authority to place a condition on the special permit that the buffer zone not be 6 feet, but be some lesser amount?
Well, that's where Attorney Efron and I differ in terms of the interpretation of 5.4.2. If I review it in its strictest sense, or I interpret it in its strictest sense, I would say no, it's not within your discretion. That's within the planning board's discretion under section 5.4.7, which allows them to do exactly that by way of a special permit. I suppose, and we would be careful in how we craft a condition of this sort, that you could include a condition that you deem section 5.4.2 to be substantially complied with by virtue of X, Y, or Z being done on the site. For example, if you were to review the westerly boundary of Lot 2 and the fact that, as I said, it's impossible based upon the site plan to provide a continuous buffer of 6 feet, you can in fact see the 6-foot mark there. There's a spot where they've shown 6 feet, and where that brings you to, you can see that along the immediately adjacent to the parking spaces, you've got these little sort of half islands that could in fact be landscaped. But then you've got these gaps that are required for maneuverability. I guess suppose an argument could be made by the board that those gaps are still sort of consistent with the purpose and intent of 5.4.2, which is to provide a buffer, and you're allowing the gaps in the interest of better maneuverability and public safety, and so you're deeming it to be in compliance with 5.4.2. That's about as far as I'd be willing to go.
I like that, I think.
What do we do with the westerly, I guess, side of the Trainer property where there doesn't seem to be a buffer there at all? Where the 10 spots are.
Yeah, and I see it. Doesn't look like there's 6 feet.
No, it's because it's tapering too.
Some of the snow disposal area, the wider spot, probably, but it goes down.
Nothing.
Goes downhill rapidly from there.
You don't mind if we huddle while you're talking too, do you? Quiet.
So, is it possible for us to make a condition that this space be put together with trees in it, or they work out a deal with the landowner to take care of what's going to go there?
No, we said that we're not going to make out, allow
I don't think
any.
we have that, we don't have that.
Stay away from the landowner being.
Yeah, we're not going to
required
get the landowners involved, or they said they don't want to be involved.
Yeah.
The only thing you can do in an instance like, not the only thing, but one of the things you can do in an instance like this, and it's not ideal, but because it increases the risk of an appeal, frankly, by the applicant. But one thing you can do is you could require full compliance with a provision like section 5.4.2, and then you can include a caveat or a provision that states, provided, however, that the applicant may provide the aforesaid 6-foot wide buffer by other means, e.g. on adjacent property through agreement with neighboring landowners if feasible. That way you're sort of putting the applicant in a position where they've got two options. Option one would be modify, for example, the westerly side of Lot 2 to provide that consistent 6-foot buffer. That's going to require them to lose probably 1, 2, 3, 4, 5 car spaces. They're going to have to bump that all out by 6 feet. They're going to lose 5 spaces. So they can either make that choice to lose 5 spaces and whatever that entails, or they can choose to talk to the neighbors and try to come to some agreement. We're going to pay some to put some landscaping on your property. Because it's an either or, I wouldn't want you to just say you've got to work it out with the neighbors, because you put them in a position where the neighbors can then hold them hostage and they have a permit that's not usable. But that gives them the ability to use the permit, but they're going to lose some spaces. The risk there is that they decide they don't want to do either and they appeal. So you sort of have to weigh the risk of an appeal against what the effect of your condition is. Is the loss of 5 spaces, 5 vehicle spaces as opposed to 5 bus spaces, is that going to be a significant enough impact on their bottom line for the applicant to choose to spend what could be tens of thousands of dollars appealing a decision, or not? Or are they just going to accept it and revise their plan
But that
accordingly?
would only be for very specific section.
In my example, I was just addressing the westerly boundary of Lot 2, but you're right. I mean, you've got you've got other areas with the same issues.
So we could draft a decision or a condition that says either comply and have 6 feet with bushes in it, or ask the adjacent neighbors if they want to have something on their property.
Right, you're essentially requiring that there be some 6-foot landscape buffer, and you don't care whether it's on their property or on adjacent property. That's up to them, and if they can work out a deal with the neighbors to put it on adjacent property, good for them. If they can't, they've got to adjust the plan. But again, you just sort of have to recognize the example I gave was maybe not the best of the examples, because I talked about losing 5 spaces, which is what would happen on the westerly side of Lot 2. On the northerly side of Lot 2, where you've got that triangle-shaped snow disposal area, that's more challenging, because to widen that to 6 feet all around, you're going to lose several spaces. You're sort of throwing that all out of configuration there. So that's, again, I'm no engineer, but my sense is that they could lose several more spaces there, assuming that those aisles are the narrowest they can be to still be compliant.
Doesn't that then negate the site plan as submitted?
Well, it does, except so I would include, if I were to state something like that, I would say that you would acknowledge in the condition that would require a modification of the site plan, which you're allowing to have happen. So we, thinking back to an example of this, was the Dunkin' Donuts approval on Pond Street from a number of years back, and there was originally, or finally, in the last version of the plan that was before the board, there was a point of access from Pond Street, if I recall, and the planning board didn't want that access, and they'd negotiated through the process with the applicant, but the applicant was adamant that the access needed to be provided. And ultimately, they approved it without the access. Of course, the plan they had that they were approving showed the access. So I drafted a condition as part of their decision that approved it, but with an acknowledgement that per the conditions of their decision, that access would be closed off. The area would be a continuous landscape buffer, as was already existing on either side of the proposed access, would be landscaped, and that we acknowledge the plans that were ultimately submitted to the building inspector for the building permit would have those changes made without the need for a reappearance before the board, because obviously it was the board's own condition that was requiring that the need for that change. So it can be done.
That, what Adam is suggesting, I think, appeals to me as perhaps the way to go in this instance. It gives the neighbors the buffer zone that they feel they need and that they may well be entitled to, and probably are entitled to, and gives the applicant the option of providing that either on its property or making an agreement with the butter to do otherwise.
But we have to assume that the abutters are not going to give them the permission.
They may not.
Then what do we ask the applicant to do? Then they have to modify the site plan.
They would have to modify it and either accept it and modify it or
appeal it,
presumably.
Yeah.
I would suggest we go with the sort of the option, as I may call it, that Adam suggested with respect to the 6 foot, the applicant having the option at that point, and
Can't hear you back here.
proceed from there.
So that's one option. One option is to include that sort of a condition. The other option is what you started with, which is to determine that there's been substantial compliance with section 5.4 by virtue of what they've submitted.
Okay. What do you feel about that?
I think we have to be more definitive. It's just my opinion.
And definitive in what way?
Ruling out the options.
Okay.
Ruling out giving the butters options.
Suggesting that the requiring the 6 foot buffer where
If
possible.
that's the case, they have to lose those spots to preserve the buffer.
Okay.
Then we're totally consistent in the whole project.
Brian?
I think a hybrid of the two, they either have to come up with the 6 foot buffer space all the way around the neighborhood spots there, or unless the homeowner wants to put a tree there on their side.
But don't forget, we heard from the residents that it's the responsibility of the applicant to provide landscaping, period.
And that would give the applicant then the option of, if they can't make reach an agreement to the requirement becomes theirs to fulfill on their property.
Yeah, I don't know how successful they're gonna be in negotiating with the abutters,
Well, I'm not sure.
but how are we gonna write that in?
I'm looking at Adam because that's going to be his job if that's what we decide to do.
Right. So, I mean, the challenge is, and, you know, this hasn't been, I'm not suggesting it should have been, but this hasn't been, you know, the traditional, more extensive development of an otherwise vacant site where you've got your own consulting engineer who's been involved in reviewing the site plan, who you might consult for advice on, well, what's the effect? I mean, you're looking to me, and I'm giving you engineering advice as to the effects of adding a 6 foot buffer on the northerly side of Lot 2, and I'm no engineer. And you don't have a consultant to ask those same questions. So you just need to recognize the consequence of whatever direction you go in. If you go in the direction of determining substantial compliance with the plan as is, there's a possibility you get challenged on that point. That challenge would presumably come from somebody other than the developer. If you go the route of mandating a 6 foot wide landscape buffer along rear and side lot lines, consistent with the explicit language as I read it of section 5.4, you risk sort of throwing the whole site out of whack. And in doing that, the applicant being told by its engineer that they can't get nearly the number of parking spaces that they had proposed, and that the only option for them is to challenge it. And then again, you get an appeal, only now instead of from somebody other than the applicant, it's from the applicant. So there are risks no matter which approach you choose. But the question really for you is, you know, how best do you interpret section 5.4, and then how do you weigh the plan that's before you in light of that interpretation and in consideration of the site as it exists today?
So there's no way to really tell if the site plan is operational, if those spots have to go for trees.
There's certainly no way for me to tell. I'm no engineer. I imagine that there is a way to tell, but not based upon the information that you presently have. And I don't want to speak for the applicant. My guess is, had you asked that an hour ago, you might have been told we're not redesigning the site to add 6 foot buffers and trying to size this out and tell you whether there's adequate aisle width and number of spaces still satisfies our need.
But what is the overarching requirement? The landscaping for the zoning board, the zoning laws has to take effect, correct?
That's my interpretation. You've heard a different interpretation from Attorney Efron. His opinion is different than mine with respect to how Section 5.4 gets interpreted.
So the legal consequences are we could propose the landscaping plan, and then there's an appeal process, and we would be notified during the appeal process that our plan is not functional. They can't operate without those parking spaces.
They could use that as a basis for their appeal. I'm sure that would be one of the bases for their appeal. Sure.
We don't have too many choices.
You know, in looking at the plans, it seems as though much of the site is does have the 6-foot spot. If you look at lot 3, it does appear to be 6 feet. But looking mostly at lot 2, where the majority of the abutters are, if I'm reading the plans correctly, much of the site is a 6-foot site, 6 foot. Going along the Trainer property is where it appears not to be 6 feet, and that's along the very rear edge of that property. I suppose it comes down to a definition of what substantial compliance is.
But on lot 2 is where we got the most pushback by the abutters.
Correct.
In terms of their opposition to.
Oh, no, I understand that.
To looking at the, so landscaping is definitely required there. So the question is for the applicant to determine if they can live without those spots. That would have to be eliminated to accomplish the correct landscaping plan to be consistent with the entire project. So I would vote to continue the continuity of the landscaping design for the entire project, and we have to see how it reacts to the applicant.
It's called an appeal.
We have no choice.
Right, we have no choice. If we uphold the bylaw,
right,
we have to go. That's the way we have to go. Without getting too technical and whatnot, it's beyond us to do that technically, to say that, I think.
I mean, I think I'm leaning towards the option that Adam had mentioned, which is to, impose the 6 foot, but give the applicant the option on those such area where the 6 foot is not present on the present design, to either change the plan or eliminate the spaces to allow for the 6 foot, or make an accommodation with the property owner to allow for that.
But I think you all, are you also then stating that if they can't make the accommodation, the fallback position is the
Yes.
6 foot? Well, you could try that, sure.
That's not what I understood one of the possibilities was. I think in that way we give we require the buffer zone, and the applicant can determine how it wishes to comply with that buffer zone.
I agree with that.
Agreed?
Yes.
Okay. And that's a condition that you will write?
Sure.
Okay, thank you.
Yeah, I'm not sure how I would word that one.
That's why we have town council.
Yeah, yep.
there other conditions that we have not talked about that other members wish to impose?
I'm not aware of any.
I think I've got everything that was on my list. With respect to the buffer zone,
So that's 19.
do we want to, no, never mind. Let me do that. Any other conditions that we have not talked about? Adam, any conditions that routinely we would consider that we have not addressed through inadvertence, given the number of conditions that are involved? I know these number of conditions may be small compared to what the planning board often does, but for our board, in my limited experience on it, it seems like a fairly large number of conditions.
No, so I don't have anything sort of on the spot, but I suspect, are you going to have Josh draft your decision? Is that the plan? And then
we hadn't talked about that, frankly. Typically, what Josh has been doing is drafting the decisions. This one strikes me, frankly, as much more complicated than our usual special permit hearing, and that perhaps we should speak with our town manager to see if it would be appropriate to have town council draft a decision.
So you can speak to the town manager about that. I'm certainly happy to draft it if the board chooses, and if it's authorized. The other option, of course, is to have Josh prepare the decision. I would certainly review it. At the very least, I would provide to him the condition that we just discussed. But I can review the decision as a whole. But again, I defer to the board and to the town manager. I asked the question because I presume that whether it's me drafting it or it's Josh drafting it, you'll use the standard form of decision that you've been using for a few years now for most special permits that have come before you. And that's a form that I drafted a number of years back. So it includes a number of standard conditions, the sorts of things that have even been discussed over the course of the evening tonight. Things like the approval does not constitute an approval under any other bylaw, rule, regulation of the town, and that any other applicable bylaws, rules, regulations of other boards, commission, committees shall be complied with. Compliance with all local, state, federal laws is required. The standard provision concerning outstanding taxes due on the property constitutes a revocation of the permit or a basis for revocation of the permit. So the usual lapse provision concerning special permits, 2 years, things along those lines. So I'd want to be sure that all those make their way in, but I suspect that they will if you use the standard form.
Let me ask this, and perhaps we overlooked it. The 6 criteria that we've talked about under 9.3.2 that we have to make findings of, we sort of skipped over those, didn't we?
So you haven't discussed them yet, and typically what I would recommend, and I will recommend it tonight, is that you not proceed to a vote on the application tonight, because once you do that, you're under a 14-day clock to file your decision.
Right.
What I would suggest you do is just confirm essentially the straw poll that you've taken a few times tonight, that you're all generally comfortable, or the voting members are comfortable with the conditions that have been discussed, and then direct me or Josh or both of us to draft the decision on behalf of the board, which we'll review at the next meeting. So I think it would be helpful to Josh, to me, to have some discussion about those various criteria so we can fashion the standards. I've got a lot, and I've got several notes of the things you referenced tonight that I think will form a basis for those findings, but if you want to walk through them, that can only help.
I think that would be very good, and I apologize because normally we do this first, and we got to the item of conditions before we really got to this. 9.3.2 criteria: special permit shall be granted unless otherwise specified herein, only upon its written determination that the adverse effects of the proposed use will not outweigh its beneficial impacts to the town or the neighborhood in view of the particular characteristics of the site and of the proposal in relation to that site. In addition to any specific factors that may be set forth in this bylaw, the determination shall include consideration of each of the following: community needs served by the proposal. Well, we have heard that the town of Ashland requires the bus company that operates its school buses to park its buses on within the town of Ashland, and that community need and requirement would be met by the granting of this special permit. Any other thoughts on that? 2, traffic flow and safety, including parking and loading. Well, we certainly, with the conditions imposed, restricted bus and vehicle traffic on the 2 roads adjacent to the property. The parking has been provided for by requiring lined parking spaces for buses. The buses have been moved on Lot 2 away from the neighborhood to the Chestnut Street side of the property. Loading would not seem to be an issue, but requiring the buses to enter to and from Brook Street and no use on Columbus Street for either buses or drivers in their personal cars would seem to have addressed traffic flow and safety.
I think we should also add that the fact that the applicant has a supervisory personnel there to make sure that those rules are adhered to.
Very good point. 3, adequacy of utilities and other public services. Would not appear to be any issue concerning utilities. 4, neighborhood character and social structures. We are in a situation where we have commercial zoning and a residential neighborhood as part of that commercial zoning, and attempting to have the 2 coexist. The lots have been used for parking for many years in one capacity or another, and this would not significantly change the use of these two lots, I would suggest. In agreement?
Yes.
5, impacts on the natural environment. The lots have been, lot 3 especially, the one nearest the brook has been used for a number of years for school bus parking. There would not appear to be any more impact on the natural environment than what has been presently seen. And 6, potential fiscal impact, including impact on town services, tax base, and employment. Would not seem to be any increase in town services or employment. As far as the tax base, the excise taxes for the buses that are parked there would have to be paid, and that money would go to the town of Ashland, whatever that amount of money is, so that if there is parking of some more buses than what are presently parked there, then the tax base would be increased. I think that covers the 6 points. Is there anything else that we need to cover with respect to that?
I'm good.
I think Adam's suggestion that we continue this matter until our next meeting so that we can see a draft decision, go over all of the findings and all of the conditions, review it before we formally take a vote would be most appropriate.
I agree.
Now, our next scheduled meeting, which would be the second Tuesday in
Tuesday in June.
June, which
Yeah.
would be, somebody get the calendar before we all reach for our cell phones and.
June 13th,
June 13th.
Wow,
Tuesday, June 13th.
it is June 13th. Do I hear a motion to continue the matter
Make a motion that we continue the matter for June 13th.
and perhaps at 7:05? We have nothing further, nothing else scheduled
We
at
do
this
not
point
have
in time?
anything scheduled.
Mr. Chairman, it's not a public hearing because the hearing's been closed, so there's no need to continue it to a specific time. You can simply
Okay.
continue it to your meeting, which commences at 7 o'clock, and you can place it wherever you'd like on the agenda. It's simply a deliberation session.
Thank you for that clarification. Then we have a motion to continue to Tuesday, June 13th. Is there a second?
I second that.
All in favor? Aye. Opposed? Abstained? Okay. So, this matter is concluded for this evening. We will see many of you back on June 13th. This was wonderful.
You're awesome, as usual.
Yes, we are. We do have some matters to.
Do we have to sign something?
We do have to
Yes.
sign something. We have something.
A couple
else.
things. I'm gonna
Do we want a 5-minute recess to stretch, or we want to keep going?
I'm going to explode otherwise.
Yeah, the meeting's adjourned.
We recess for 5 minutes.
We don't need a motion to recess, do we? You do. Is there a motion to recess for 5
I'm
minutes?
so moved.
Second? Aye.
Aye.
WACA, we're going to recess for
Don't get in
5.
my way.
Thank you and welcome back. We're going to the next item on our agenda this evening, which is end of meeting, review and signing of decisions for 366 Elliott Street, the special permit, 3537 Lakeside Drive special permit, and 133 West Union remanded comprehensive permit as voted on May 9th, 2017. We have the decision for 366 Elliott Street was submitted to each of us via email by Josh, and he has now provided the final form here for us. Were there any questions or proposed changes or discussion on that one? If not, we just need to sign it.
Yeah, there were two small changes that the acting chair brought up. One was formatting, which, you know, and then one, there was also a word changed in the first paragraph of section 5. Swapped out a word for clarity. Those are the only two changes. So I have them here. I have 3 copies. If you could sign each one. For Elliott Street, it was Brian, Stu, and Phil. I believe Phil will be stopping off at Town Hall tomorrow, so he can sign that at that time.
This is like buying a house. Oh, okay.
Stu,
And there's no
Phil,
check.
And Brian.
So this,
for
this
that
go
one.
to Brian, right?
Yeah.
Pass them along and Brian can be signed.
There you go.
This goes to Brian.
Yeah. And then on the special permit for 35 and 37 Lakeside, there aren't any changes that I am aware of. So, and that was, I think, Brian, Stu, and John, if I'm not mistaken.
Correct.
Yeah. Those ones. While that's happening, there are blue binders in front of you, which you may have noticed. Those contain everything that I think a ZBA member may need. It's got the bylaws for the town. It's got MGL Chapter 40A. It's got some 40B guidance in there. So I was not sure that all board members had absolutely, possibly everything And so now you all have everything.
Thank you for that.
So, yeah.
Yeah. There you go.
Okay, that then leads us to 133 West Union remanded comprehensive permit is voted on May 9th, 2017, and I will turn it over to Town Council.
Thank you, Mr. Chairman. So I've drafted the relatively short, sweet, and to the point decision from your May 9th meeting relative to the 133 West Union Street project, and specifically the hearing that was conducted on the modification to the project per mediation that occurred in the context of the Housing Appeals Committee case number 216-17. I'll read my decision to you so you all don't have to read it individually, because it'll probably be faster that way. It's only a few paragraphs, particularly where the board denied the request. There wasn't a need to provide for conditions or to cite with any degree of detail the basis for the board's decision. So it says, at a public hearing commenced and concluded on May 9, 2017, the Zoning Board of Appeals for the Town of Ashland reviewed the request of Capital Group Properties to modify the October 6, 2016 comprehensive permit issued for the development known as the Residences at West Union, located at an approximately 7.62 acre site known as and numbered 133 West Union Street in Ashland. Said comprehensive permit was appealed by the applicant to the Housing Appeals Committee. Consideration of the modification request was pursuant to an order of remand issued by the HAC dated February 28, 2017 in case number 2016-17. Modifications sought by the applicant included reconsideration of the board's denial or partial denial of waivers from sections 4.1.1 and 5.1.2 of the town zoning bylaw, namely the table of dimensional requirements and the schedule of parking area requirements, respectively, to permit the development of a 120-unit multifamily housing project with pertinent parking and other amenities, reconfigured as depicted on preliminary plans submitted to the board with or subsequent to the applicant's request. After due consideration, the board found that the requested modifications to the comprehensive permit are not, quote, consistent with local needs, unquote, as defined by General Laws, Chapter 40B, Section 20, and by 760 CMR 56.02, nor do the conditions of the comprehensive permit, as originally granted, make the construction or operation of the proposed project, quote, uneconomic, unquote, also as defined by Chapter 40B, Section 20, and 760 CMR 56.02, in that the applicant may proceed with the project as approved and still realize a reasonable return on investment. On motion to deny the aforesaid modifications to the comprehensive permit, the following members of the board vote to deny the applicant's requested modifications to the comprehensive permit as above described. And there are signature lines and a date for filing with the town clerk. I think that summarizes the sum and substance of what was discussed, obviously much more briefly, back on May 9th. So my records and your meeting minutes indicate that this was voted on by Stu, John, and by Phil.
Correct.
So the two of you will have to sign this, and then if Phil comes by tomorrow, he can sign it separately. You've already voted this decision. You voted at the conclusion of your May 9th meeting. So if that happens, and then if you could, Josh, facilitate getting this filed with the town clerk once Phil signs it, that'd be great.
Yep.
Thank you.
Given the lateness of the hour, I would suggest that we table the staff updates and administration, discussion of board vacancies and membership, and await the next meeting when we may have an opportunity to discuss this matter, and Phil will be in attendance and should probably be leading the discussion on that, those
Yeah.
subjects.
Yep. If I could, the ZBA application form, all the recommended changes have been made, and I'm just waiting for an actual stamp of approval on that.
Okay.
I don't know if you want to take up that or
Can that
table it
wait
as
till
well?
the next meeting, or you'd like to get it done now, because it's been pending for quite some time, hasn't it?
I would, but I mean.
We don't really need a
wanna
formal
wait.
vote on that, do we? It's simply a matter of,
Yeah, it's
we've
an
had input to it,
administrative-
and it's
Administrative, yeah,
administrative
there's no-
issue, and you've done a lot of work with it, and I think it's good to
I
roll
mean,
out.
I was reading it, and it looks good to me.
I've reviewed it and passed comments to
Yep.
Josh, and he's
Yep.
incorporated it. I think everyone else has.
Yeah, I think it's fine.
Okay,
Is that all right, Brian?
Yes.
Okay, then we'll implement it.
great.
I move
Chair
that
would
we
entertain-
adjourn.
That's what I was entertained. Is there a second? All in favor? Aye.
At
Opposed?
10 of
Thank you.
11.
Thank you, WACA.